Lordships, I'm appearing on behalf of the respondents in this particular matter. I have informed the learned counsel for the petitioner. I'm seeking 2 weeks' time to file my affidavit in opposition, Your Lordships.
5-8.
5-8, yes, Your Lordship. Our names, standing counsel Asalsa is not being reflected here, if that may kindly be.
The request of MS R. Chaudhary, appearing for the
Respond number
respondent
3, Your Lordship.
number 3.
Lordship.
Matter stands adjourned for
2 weeks, Your Lordship.
2 weeks. It is submitted. The consent of the counsel for petitioner has been obtained, and the registry is to reflect the names of all counsels, including the standing counsel for Asalsa.
Asalsa. Deeply obliged.
Actually, my lord, that may be reflected, my lord. He is taking time for filing affidavit, my lord.
Yes, Your Lordship.
That
Of
may
course.
be reflected.
That will be, let be listed after reopening, 19 July.
No, no,
Yes,
my
sir.
learned friend is saying that I'm taking time for filing an
Filing.
affidavit that may be reflected.
That may be reflected.
Okay. Counsel for the respondent has prayed for time to file affidavit.
Deeply obliged.
Problem.
May I please, Your Lordship, I beg to mention for listing of a contempt petition civil or orders. Any that may,
Fresh matter, new matter, old
no,
matter.
no, always notice
Notice it.
issued for orders.
When was it last listed?
Last listed on 8/4/24.
Let it be on 14th.
Any that may be given.
14th
For
June.
obliged.
May I please, Your Lordship? So I beg to mention for listing, Lordship.
What is the subject matter?
Lordship, the
Subject
matter,
matter.
Lordship,
What is the subject matter?
Lordship, subject matter is the regarding the settlement of ferry services at Nagarbra, Kamrup, Lordship.
Very sir.
Whereas the petition was the highest bidder, Lordship.
It's an old matter, new matter.
Lordship, earlier listed on 8/4, Lordship.
8-4.
Lordship, issued, Lordship.
All right, 14th.
Lordship, kindly on 13, Lordship.
13, no. 13 not possible. We can have it on, 14th is good, or we can have it on 18.
Lordship, 14.
14?
Lordship, I beg to mention item number 40. Lordship, my senior is out of
Item
40.
1440.
Lordship, 40. Lordship, my senior is out of station. Kindly
Who is your senior?
SCK, Lordship.
So you please, have you contacted the
Yes,
concerned?
Petitioners, there is the interim that may continue.
Okay,
They yet to
request
file
of
the affidavit, so it may be posted after the vacation.
MS so-and-so matter stands adjourned for 3 weeks. As it is submitted that the counsel for the respondent, Mr. Jal, is not in station. Mr. P. Gogoi, learned counsel, appears for the petition and does not object to the prayer made. However, submits that the interim order passed earlier will continue. May continue. Accordingly, matter be listed again in the month of July on a date to be fixed by the registry. Interim orders passed earlier will continue.
Highly obliged.
May I please, Your Lordship, counsel taken from the opposite party, Lordship, I beg to mention item 57. Lordship.
1557. Yes. IA,
I, Lordship.
at the request of Mr.
JM Google.
J.M. Gogoi, matter stands adjourned for 3 weeks. Is submitted. Consent of the counsel for the opposite party has also been obtained.
May please, Lordship, I beg to mention item 47, my lord. I have taken consent from the other side, my lord. Let it become after vacation, my lord.
47.
47, my lord.
You are for
And for the petitioner, my lord.
the petitioner. Item 47 at the request of learned counsel. Matter stands adjourned. It is submitted. Consent of the counsel for the petitioner has also been obtained.
Much obliged.
May I please, Your Lordship, I beg to mention item number 15 with the consent of my learned friend. We'll file our affidavit in reply.
Item
Item 15.
15.
We'll file our affidavit in reply today.
Yes, item 15. At the request of Mr. Swansol, learned counsel for the respondent, with the consent of the counsel for the petitioner, matter stands adjourned for 3 weeks, enabling them to file affidavit.
I'm appearing for respondent number 4.
In this matter,
Yes, Lord.
Yes, Lord.
you are making prayer on behalf of petitioner.
Yes, Lord.
Okay, petitioner. Counsel of no objection is raised by the counsel for the petition, respondent. Matter
2
adjourned.
weeks time may be given.
3 weeks.
Okay.
May I please your lordship? Lordship, I beg to mention a petition for listing in admission column. Matter may be listed on 14.
What is the subject matter?
It is regarding bricklaying industry. The respondent has restricted us not to continue the bricklaying industry.
All right, 14.
May I please lordship? Lordship, I beg to mention a petition matter for listing lordship.
What is the subject matter?
Subject matter related with Ex-gratia lordship. Ex-gratia lordship.
Ex-gratia.
Yes, lordship. So next of kin of a deceased family lordship. In a city case lordship. Only matter may be come upon Wednesday lordship.
Hmm?
Wednesday lordship. This matter last
Wednesday.
posting 3/5/24 lordship. It is admission
Not
space.
Wednesday, let it be on 19. 19, yes.
May I please, Lordship, Lordship, pair for listing a writ petition, Lord.
What is the subject matter?
Okay, whether Lordship petitioner is a stone caster unit. Suddenly in the year 2019, the Forest Department issued a notice not to operate any
All right,
activity.
19th,
Deeply applies, Lordship.
yes.
May I please, Lordship? Two petitions regarding allotment of mutation, Lordship. Analogous cases have been disposed of by this honorable court. So it may come on Friday.
Friday,
Yes, Lord.
14, all right, 14.
Thank you, Lord.
Lordship, I am on the prayer of adjournment, item 36.
36, yes. You are making a mention on behalf of
Mr. J. Pine,
at the request of MS so-and-so, the council making a prayer on behalf of Mr. J. Pine matters for 3 weeks. Yes,
may I please your lordship? Lordship, with the consent of the other side, I beg to mention item number 48. Lordship, Mr. S.K. Kejriwal is not feeling well today. Lordship, the matter may be fixed on next Tuesday or Wednesday. Any day is for your convenience.
it will come in July. Item 48, the request of
Lordship, next week.
next week is difficult. Next week is difficult. Matter be listed after 3 weeks.
Obliged.
May I please, Your Honor? Your Honor, I am for the petitioner on the item number 32. Can we pray for adjournment? And the petitioner needs 3 weeks time for rejoinder.
You're praying on whose behalf?
Petitioner.
Petitioner, at the request of counsel for petitioner, matters then adjourned for 3 weeks to file rejoinder. Prayer allowed, list after 3 weeks. Yes.
May I please your lordship?
Yeah.
The petition is agreed by the so-called notice issued by the respondent number 5, that is in page number 53, my lord, annexure 3. There's so-called for cancellation of a registration, my lord. On the very next day, that is on 38th of May, we have filed a reply where we have honestly replied, my lord, that it is an honest mistake as I was not aware of the amendment in the ITC rules, and I will reverse the access ITC claim. My lord, the petitioner is ready to reverse the access ITC that has been claimed, my lord. And for the quarterly reverse, my lord, it should be done, my lord, without the due date. They have again issued so-called notice of notices, my lord. And on 10th of August 2023, they have canceled my GST registration. That is the page
What
number
about appeals?
61.
What about appeals?
We have not on the appeals, my lord.
You've not filed appeal. Why?
Which we,
There is
it
a
is
statutory
up-
appeal.
similar orders were there, my lord. Why we come directly to High Court.
Why? You know that
lord-
there, when there's a statutory appellate forum, you should have approached the appellate forum.
My lord, the reasons for cancellation as well as the reasons for SOCOs issuing the SOCOs, which is totally different, my lord.
Where is the cancellation order?
It is 10/8 or 61, my. Page number 61, annexure 8.
Yes. What is the reason?
Here it is written that registration is fake and ITC was availed without actual supply of goods. Whereas, my lord, on 20th of May, that is at Annexure 3, page number 53, it was shown that person avails ITC in violation of the provisions of section 16 of the Act or the rules made on thereunder, my lord. Excess ITC claim. And here, the order for cancellation is totally different, my lord.
Pursuant to the show cause, did you appear or file a reply?
Yes, we have verbally replied as well as on 30th of May, my lord. That is Annexure 55. We have already mentioned that we will reverse the excess ITC. Without waiting for that quarterly dues, my lord, they have cancelled my registration.
Yes, Mr. Gogoi.
The suppose and the, my lord, so far as the cancellation part is concerned,
Hmm.
the ground is same, my lord. It says, my lord, ITC was availed without actual supply of goods.
But fake ITC.
Page
61.
61. And my lord, the ground given is that, my lord, the petitioner was not aware about the amendment, my lord.
I have honestly replied.
Page
my lord.
55.
And the due date was not over, my lord. And we are ready to pay the access reverse ITC, my lord.
Yes, what is to be done?
One thing, my lord, the petitioner has proposed that, my lord, he will eat, my lord, reverse ITC, return it, if at all, my lord. Yes, claim, my lord, illegally. In that regard, my lord, I can have the instance. Otherwise, Lordship has already pointed out if we can go for appeal. Because, my lord, the three grounds, my lord, under which, my lord, we
Is it
Under-
in limitation? Within limitation?
problem is, it's of, my lord, 24/5. So far as the, my lord, cancellation is concerned, even 30 days is not over.
28th of May.
Within
23.
it's
2023.
23, my lord, 3 months. Otherwise,
You get the instructions. If you're willing to pay, then
yes, on that point.
on that issue.
But, my lord, whether it can be restored, my lord, registration, that is again another thing, my lord.
You get the instructions.
I will restore.
Third learned counsel for party. The petition is filed by the petitioner praying for cancellation of the registration, GST registration by the impugned order dated. Where is the order?
61 pages. Next are
Exit 10. 10th of October 2023.
24/5/2023. The petitioner submits that the cancellation was on the ground that registration is late and I input tax credit was the date without actual supply. It is submitted that the said finding is contrary to the documents available on record and whatever excess ITC which may have been claimed by the petitioner was willing to refund the same as reflected in the reply to the show cause dated, the reply dated 3005/2023 to the show cause notice issued on 29th of May 2023. However, without considering the same, the registration has been cancelled. The understanding counsel, Mr. Bull,
One
comments that he would like to obtain the required instructions. Therefore, matter will be listed after 2 weeks.
My lord.
Mr. Gogoi will obtain the required instruction. Gogoi represents the number.
1 and 2.
You represent 1 and 2. Okay, both.
I
both
appear
Mr.
for,
Gogoi.
my lord, 3, 4, 5, and
Mr. B. Gogoi for
3, 4, 5, and
3, 4, 5, and
6.
6. And Dr. Gogoi for
1 and 2.
1 and
Okay, okay.
all right. Let the extra copies be furnished within the period of this week and enabling the respondents to obtain the required instructions by the next 8 weeks.
26, my lord.
26. List on 26. June.
Yes, my lord.
May I please, your lordship? In this case, the son of the petitioners died in a road traffic accident. They have made application before the Deputy Commissioner Baksa for granting ex-gratia relief, but the application is pending.
Yes, yes, respondents, anything to submit, respondents?
Lordship may issue notice. We'll obtain instruction.
Heard issue notice, 3 weeks. MSD Hazarika appears for
And for respondent number 1, Lordship.
respondent number 1 and Mr. S. Purva for
3, 4, 5.
3, 4, 5. And Mr. Bugoi for respondent number 2. Since the councils have represented the respondents, notices are waived, extra copies be furnished within a period of 1 week from today. Matter will be listed after the return of the
Complex.
Kept it right.
Lordship, in this case, the husband of the petitioner died in a road traffic accident as a victim of road traffic accident. She made an application before the District Legal Service Authority, Bozal, but the application is lying pending.
All right, same order, heard issue notice.
Lordship, a copy of this petition has not been served on me. I apologize. I do not have it.
MS R. Chaudhary appears for respondent number 3.
Respondent number 2, Your Lordship.
2 and 3,
No, not 3. Just
only 2.
just 2.
I appear for 1, 3, and
Copy to Somnapuram.
Mr. S. Purva for 1, 3 and 4. Notice being
The daily
returned
public
about
action.
3 weeks since the learned standing council represent the respondents. Notices are waived, however, extra copies be furnished within a period of this week. Yes.
In this case, my lord, petitioner's father was killed by someone. Accordingly, she applied for under the Assam Victim Compensation Scheme. And S20 is the relevant portion of the scheme. Clause 1 of sub-clause 1 of clause 5. S20 sub-clause 1, my lord. It says, my lord, that the application shall be decided and award of compensation should be paid within 2 months of the application, my lord. Accordingly, she filed representation that is page, my lord, 41, 9/11/2023. Thereafter, she was heard and notice was issued, page 44. The District Legal Service Authority issued notice, he appeared, and till date, my lord, nothing has been done. Since it has not been decided, I have annexed the order of passed by coordinate bench of the court, my lord, that is page 46, last page 49, my lord.
Yes,
That order may be passed.
Lordships, normally I do not object to a notice being issued, but I must point out a discrepancy in my learned friend's petition. He is saying that the petitioner's father is the victim, whereas if your Lordships will look at page 41 of the petition, annexure 6,
yes,
she is saying that she's the wife of the victim. And she has also signed at page 43, she has also signed as wife of late Maji so-and-so. And there is no evidence adduced in the writ petition as to whether she is the daughter or whether she is the wife of the victim, number one. Number two, the police report has been filed by some other third person, your lordships. Supposedly her brother. If she is the daughter, then the police report at page 40, the typed copy is at page 39.
yes.
There is no evidence adduced in the petition as to what is the relationship between the petitioner and the victim, your lordships. She should perhaps appear before the DLSA concerned and verify her documents, and then necessary orders may be passed by the DLSA, your lordships. The case is in any case
Where is
pending.
where is your application which is pending?
Application, my lord, that is in application, my lord, due to
The page,
some
annexure
mistake,
6,
my
your
lord,
lordship.
instead of
Page 41, annexure
page
6.
41
This you say is pending.
pending.
You get instructions
Yes,
and find
yes.
out what is the state.
Lordships,
Yes.
I'll try and get in touch.
Heard that the council for party, they should notice. will not issue notice. Better to get the
Better to
instruction.
get instruction. Next week, Your Lordship, may fix it up on any day and I'll get the instructions.
For the respondent number 4, Assam State, Asalsa.
Not.
Submits that she would like to obtain instructions in the matter. As in the writ petition, the petitioner claims that she is the daughter of the deceased victim, and in the application which is pending, which was filed before the District Legal Services Authority (DTAD), she claims she is signed as the wife. Now she claims to be the wife of the
Deceased victim.
victim. The learned counsel, standing counsel, submit that she'd like to obtain the required instructions.
Lordship, may take it up on Friday, subject to Your Lordship's convenience.
Friday.
Lordship's
All right, Friday.
Friday. Deeply obliged.
Counsel for the petitioner will furnish extra copies to the respective standing counsels. Mr. Rava for BTAD. Mr. Borua for
The remaining barring 2.
Barring 4, I'm for the respondent number 4.
you give the name. Yes.
I'm
Obliged.
Merely. This matter pertains to the illegal formation of the Devarikari Parichalana Committee for the Jal Jeevan Mission by keeping the resident of the local Kodamuni town under complete darkness. Your Lordship. The Assam government launched an ambitious scheme called the Jal Jeevan Mission under the Rupohi Revenue Circle, where Your Lordship, a Bevahari committee was formed without the knowledge of the local public, and the rules and regulations that were being followed were not being followed by the committee. The rules and regulation, page number 14, I have annexed here with Lordship.
Who has framed this committee?
Lordship.
Who framed this committee?
This was formed by the some of their local people with the aid of the respondent number 5, who is the GT president, with some signatures from the local public in secret. But the other persons were not known about the formation of this committee, and one Manjur Motibur Rahman was elected as the president, who is also the son of
Now, how are you affected by the committee?
the Lordship, because these were formed for giving some employment to the local public also. And these are not being given to the local public. And the new proposal that was given by the committee, by the local public for a new committee which was to be constituted, is also not being accepted by the present committee. And thereby representation was also given to the DC as well as to the chief executive engineer, where a reply was also being sent and a direction was given. Page 59 is the copy of the reply by deputy commissioner to the member secretary to inquire the matter concerning regards to the complaint made by the local public and take all necessary action.
Okay, heard. Yes, anything to submit? Mr.
Uh,
Kodagu?
Lordship, here the committee is formed by the Gao Panchayat secretary, who has been included here, Lordship, as respondent 5. There is a guideline by Panchayat and Rural Development. It is an election process is supposed to take place, which is convened by the Gao Panchayat secretary. Respondent 5, Lordship.
According to the petitioner, they are not this committee was not formed as per the procedure prescribed.
Lordship, that is what the Gao Panchayat convenes the meeting to form this committee,
Right.
Lordship.
So you get instruction.
I will get it.
Right, something. We issue notice here?
Lordship.
Issue notice. Who's for PHE?
For PhD.
Mr. Rai Bota is for respondent 1, 2, 3. Mr. Borua for respondent 4. Notice on respondent number 5 by usual court and registered post. AD within 1 week from today. Matter be listed after 3 weeks.
Much obliged.
Returnable to site. Huh?
Pursuant to the order passed by this honorable court, my lord, 19/4/2024, my lord.
There is no bar for me to take up this matter.
Not, my lord, possibly not. But this is a different subject matter, my lord.
Yes.
They are basically, my lord, interlocutory application, page 14, my lord, will kindly see the prayer, my lord.
Fourteen. One
Page
four.
14. Okay, my lord.
Yes.
So they have asked for any of the documents out of the 17 numbers of documents as per Annexure A and Z. And this honorable court directed us to produce 2 documents, my lord, among these like 17 documents,
Let us see the order of the court first.
my lord. The
Order
that your
dated
lordship will pay page
13/9/2023.
page 24. Operative portion, my lord, will find page 26, last paragraph. Having regard to the facts and circumstances of the case in its entirety, it is hereby ordered that the petitioner company shall furnish a proof of latest address of the corporate office as well as local admin office, if necessary, by sending electronic version of the relevant documents through email. Upon receipt of such document, the respondent bank shall activate the account of the petitioner within 24 hours thereafter. It is made clear that if the bank is not satisfied with the documentary evidence furnished by the petitioner company as address proof, the same shall be brought to the notice of the court by filing proper pleading, but that shall not be a ground for the bank to continue with the freezing of the account without obtaining the leave of the court.
What is the effect of this order?
My lord, they unfreeze the account thereafter, my lord. They unfreeze the account
Huh.
after the documents as per
They means?
that, my lord.
They means
My
your
lord,
client.
the bank.
The bank.
Bank.
You're for the company.
I'm from the company.
Okay.
Thereafter, my lord, there were freezing thereafter also, but they have come up with this application of IA, my lord, for vacating the stay order or modifying to the extent directing us to submit the documents as it is listed among the 17 documents. This on
How is this maintainable? This was an inter-party order.
Yeah.
If you're
My lord-
aggrieved, you can go and appeal.
Let's say before your lordship take up the interlocutory application, what I want to submit, my lord. The reason behind of filing this writ petition, I mean to say the cause of action. The request, it is the request made by the respondent number 3, 4, and 5, that is the Axis Bank Limited, to the writ petitioner to submit his KYC documents before the bank in a normal course of procedure, my lord. My lord, whatever action the bank has taken or whatever request the bank has made to the writ petitioner, all actions are guided by the guidelines framed by the Reserve Bank of India. There is no dispute to that, my lord. So, my lord, in course of that guidelines or in pursuance of the guidelines made by the Reserve Bank of India, we have requested the writ petitioner to submit his address proof because, my lord, in the writ petition, my lord, the writ petitioner has given 2 addresses. One, his local
You are
admin office.
representing the Axis Bank.
Yes, my lord. Respondent number 3, 4, and 5.
You give a notice and close the account.
That's all I want to submit, my lord.
Uh.
Now, my lord, as per the available list of 17 documents which we have.
No, we are here to find out whether this order passed by the court needs to be modified or vacated. That's all. In the IA.
Yes, my lord.
possibly, my lord, the prayer has become infrastructure.
No, my lord. No, my lord.
Why?
If my learned friend
I'll
finishes
point out.
submission, then I can submit.
No, no, I'll point out.
My lord, as per the order dated 13/9/2023. Relevant page at page number 26, my lord, at the
Yes.
middle person.
Yeah.
At this stage, Mr. Kaushik submitted the address proof as sought for by the bank would be furnished by the petitioners during the course of the day. During the course of the day, my lord. So the order of the learned court is that the writ petitioner will submit his address proof, valid address proof from the list of 17 documents during the course of the day. That was not done, my lord. As because it was not done, we have come up with this interlocutory application for vacation of the interim order, my lord. Now, my lord, as per the guidelines issued or framed by the RBI, my lord, may I submit this copy of the guideline, my lord?
You have been given liberty to bring it to the notice of the court regarding the documents are not proper.
Yes, my lord. That I have annexed, that I have bring into notice by filing of this interlocutory application.
No,
my
but
lord.
filing of the interlocutory application is not necessary for bringing to the notice of the court.
As well as my additional, as well as my evidence, as well as my affidavit, my lord. Affidavit in opposition, my lord. My lord, as per the guidelines issued by the Reserve Bank of India, which I have submitted before your lordship.
No, this order,
Yes,
you have
my
been
lord.
directed to defreeze the account.
We have defeased, my lord.
We have defreezed. Now, what is left to be vacated here?
No, my lord, as per the RBI guideline, my lord, the
That is to
petitioner,
be heard in the writ petition. You bring it by way, you said you filed an affidavit. That can be disposed of.
I may be allowed to file an additional affidavit, my lord.
You file it.
And my lord, whatever action we have taken, these are all guided by the guidelines of RBI, but the RBI has not appeared.
BI has not appeared.
Because well, tomorrow they will say that you have.
You have not filed a petition, they have filed a petition.
Yes, sir.
Well, if I may point out one thing, Miller, what my learned friend has said, Miller, that within 24 hours we did not submit. This is their pleading in their affidavit, Miller, the interlocutory application, that within 24 hours we have submitted the document, but that they are not satisfied with those documents.
Because they are not.
You want to
doing
file an additional affidavit where in the IA or the writ petition?
in the writ petition, my lord.
Then we'll close this IA.
At this stage, it may not be closed, my lord, because as per the
Your
RBI
lordship will
guidelines, we
kindly
supposed-
peruse 19/4/24 order, my
Let
lord,
him
in
bring
the
it on
IA
record. Let him bring it on record.
My lord.
If you're not hearing this matter, let us not waste
My
time.
lord.
Heard learned counsel for the parties, this learned counsel for the applicant craves leave of the court to file an additional affidavit in the proceeding. He prays for
3 weeks time.
3 weeks time. Accordingly, Mr. Kaushik appears for the respondent, opposite party / petitioner. Accordingly, the matter be listed after 3 weeks on a date to be fixed by the registry.
So the interim order may be done.
The interim order passed on so and so date will continue.
Date may kindly be
Yes,
given, my lord.
yes, yes.
Date may kindly be fixed.
On a
Date
date
may
to be fixed by the registry.
Lord.
Registry will fix a date.
Grateful, man. Obliged.
My lord, in this batch, we are appearing in my lord's item number 7 as a petitioner, and in the other cases, we are the private respondent. My lord, I pray for 7 days time to file an affidavit, bringing on record certain facts, madam.
Yes. What do you say?
Lordship, so far as the main case is concerned, Lordship, that is almost settled. Lordship, government has took a decision to acquire the land in concern.
Well, basically, some dispute is going on amongst the members of that society in whose favor the land was given. Well, certain facts have been brought to the notice of this honorable court. But we find, my lord, the correct facts are not before the court. So I pray for 7 days time to file an affidavit. On the substantive issue, my lord, there is no problem.
All right. Mr. N. Chaudhary, learned senior counsel, assisted by Mr. N. Gautam, admits that an additional affidavit is required to be brought on the court to place before the court certain additional facts and events which are relevant for the purposes of the present proceeding. He prays for 2 weeks time. 1 week's time. Mr. Nayak appears for,
I'm appearing for GMDA, Lord.
or appears for GMDA, MSN, M. Bormon for
1 and 3.
1 and 3. Ms. G. Hazarika for respondent number 2. In view of the prayers made, not objected to by the counsel for the respondent, matter stands adjourned to be listed after 1 week.
Okay.
Mr. R. Mazumdar, Mr. E. Biswas, Mr. A. Thor appears for, for the petitioners in item number so and so. You give the
item 8.
give the list of names in the chat. Yes.
And the petitioner has laid this petition for the consideration, whether the Brickfield which he is operating, my lord, can be, my lord, directed to be shut down. Because, my lord, under the environmental laws, my lord, it is not the absolute proposition that the Brickfield cannot operate at all, my lord. There are, my lord, certain norms under which, my lord, the Brickfield has to operate. And basically it is the norms of emission which relate to the, my lord, pollution. Now, my lord, without giving a finding as to whether the, my lord, the levels of pollution is exceeding the, my lord, parameters, my lord, given in the Environmental Protection Act, my lord, the direction can be passed, my lord, unilaterally to shut down the brick industry. That is the question to be decided, my lord.
So there is an interim order.
My lord, there is an interim order, my lord.
You are currently operating the
Yes,
Brickfield. So who's for the pollution control?
I am for pollution. My role is limited. Here only the circle officer has passed the order whereby this closure notice has been issued.
Where is the impugned notice?
Impugned notice, your lordship find, my lord, that page 153.
153.
My lord, annexure 11.
Page
153.
Who's for the revenue department?
11.
Who's for this revenue? Who's for respondent 6?
Opponent 6 will be represented by government advocate, Lord.
Who is the government advocate?
That's it. He will appear for the government.
Mr. Talukdar, challenge is made with regard to page 153 of the writ petition. There's a closure notice issued by the circle officer.
153, my lord.
153. And there is an interim order operating. And this is pursuant to the issuance of the Pollution Control Board. Where is the Pollution Control Board order?
Pollution Control Board order, my lord. Perhaps it is at page 93, my lord. Page 95, my lord.
Closed. এনেকে কি ইনস্টিটিউটে একেলগে পঢ়িছো 95 হ'ব নোৱাৰে
95 নহয়, above 95.
Why all these brick kilns have filed joint petitions? There are several petitioners.
My lord. The course of action was the same, my lord, and this, with this single notice, my lord, this notice was sent to everybody, my lord. That is why they have come with it, because there was a similar course of action.
সব বেলেগ বেলেগ ডিস্ট্রিক্ট কেনেকে হ'ব
Misgender party.
these are all from different districts rather
Different district.
No, from Gola.
no one is from uh, Golaghat
Different identities. All from Golaghat, my lord. These are all from Golaghat, and this similar notice was issued to everybody. Just the names were different, my lord.
I think the governments will have to file something here, especially the pollution control. It is on the basis of your order that the circle officer is issued. It's apparent from the impugned order.
pollution control in pursuant to the
You have to respond to this. Although notice in the matter heard, he was Chaudhary, so to the petitioner, Mr. B. J. Talukdar, and Mr. S. Purva for pollution control. Although notices in the matter was issued on 13/2/2019, and an interim order was granted staying the effect of the impugned order dated 24th of January 2018.
Advocate General Advocate General.
Accordingly. However, in spite of opportunities granted, the respondents have not filed their affidavit. Purely for the ends of justice, we permit another 3 weeks further time
Right.
the respondents to file their respective affidavits, failing which the matter may be proceeded with on the basis of the pleadings available on record. Matter be listed after 3 weeks on a date to be fixed by the registry. Interim order passed, so and so will continue.
Also, in this matter, the forest department is also a party. So they are necessary party because ultimately the order has been passed based on the National Green Tribunal's order.
Why
So they
don't
have
you
to
file
reply.
your affidavit
I will-
first?
I
Bring
will
it on
file-
record, then we'll decide who else are necessary.
I will file my
Just
part,
file it.
but at the
Just
same
file
time,
it.
they may also be.
You file your affidavit, we'll see whether any other party is required to be filed or not. Right? After 3 weeks.
My lord, I am for respondent, my lord. Actually, in this case, my lord, a civil suit is also pending between the parties on the same subject matter.
None appears for the petitioner.
And that statement is also in the writ petition.
None appears for the petitioner. Matter stands passed over for the day.
But the interim order, my lord, that should be continued, that should not be continued, my lord.
Have you filed a vacating petition?
Yes, no, very petition, I filed the affidavit in opposition.
You file a vacating petition if required. You are appearing for?
Respondent, number 11.
Mr. Sharma appears for respondent number 11.
My lord.
Better be listed after, may be listed next week.
My lord.
If you, yes,
Lordship, I need little accommodation. I somehow missed the brief, Lordship.
sit down, sit down. Take your breath. We will have it next week.
Okay.
Next week. Please, next week.
Lordship, this matter may be taken up after some time, Lordship.
Why?
Lordship, the conducting counsel, Mr. D.P. Bora is on legs in court number 1, Lordship, before the division bench 1.
Then it should be listed some other day.
Okay, Lordship.
Because today, after some time would be difficult.
Lordship, next week, if possible.
Next week, yes. At the request of counsel for the petitioner, matter stands adjourned for next week.
Your
Mr. Sharma for
respondent number 4.
1, 2, 3.
4. No, there are two Sharmas.
B Sharma.
M. Sharma
For respondent number 4, Canara Bank.
for respondent 4, Mr. B. Sharma for 1, 2, 3.
1, 2, 3.
Let it be listed next week.
Your Lordship, a copy may be directed to me.
You furnish a copy of the writ petition today itself.
May I break the law?
Yes.
Lordship, though the foreigner name
D voter.
even though he has declared the citizen of India by foreigner tribunal.
Where is that order of tribunal? Tribunal order?
Page 21, Your Honor. They're relying on the page 21.
21.
And extra 6.
This is only for registration,
Registration.
not declared as an Indian citizen. For registration.
You have to produce the registration certificate before the year. After, once the registration is done, thereafter, for a period of 10 years, he cannot vote. Then thereafter, his name will be removed, he will be removed. So let them appear before the year with the registration certificate if they have registered.
Yes?
Yes.
Heard learned counsel for the parties. Petitioner is agreed that although he is an Indian citizen, his name is marked as within quotes D voter in the voter list of 32, number 32, Bongaon Legislative Assembly Constitution. Stop. Counsel for the petitioner has referred to an order dated 29/7/2000 issued by the court of the then court of illegal migrants within bracket D tribunal Golpara. Stop. By the said order, it was held by the tribunal that the petitioner was registered by the FRRO at Bongaigaon on 7/8/98 for naturalization as a citizen of India. Stop. Now, whose order is this? 11-1, page number 22. She therefore submits that the petitioner's name be enlisted as a citizen of India and the endorsement within quotes the voter be removed. Stop. Mr. A.I. Ali, representing the Election Commission of India.
Respondent 3 and 5.
Respondent 3 and 5 submits that if the petitioner's name is indeed registered by the FRRO at Bongaigaon, that the petitioner may appear before the competent authority, namely the ERO.
ERO,
What is the full form?
Electoral Registration Officer
Electoral Registration Officer at Bongaigaon,
at Bongaigaon.
along with the registration certificate issued by the FRRO, and thereafter the respondents will take necessary steps to include the name of the writ petitioner in the list of citizens as a citizen.
Electoral law.
After the procedure prescribed, by following the procedure prescribed under the law. Stop. Where a counsel for the petitioner does not object to the prayer made to the submissions of the respondent counsel in view, taking into account the submissions of the respective counsel, this writ petition is closed at this stage, permitting the petitioner to appear before the ERO Bongaigaon within 30 days from the date of receipt of a certified copy of this order, and produce the original registration certificate issued by the FRRO at Bongaigaon, showing the name of the petitioner. Stop. If any such certificate and other relevant documents are produced before the ERO, the ERO will take into account such certificate issued and thereafter proceed to take the steps necessary to include the name of the writ petitioner as per the procedural law prescribed. Writ petition accordingly stands closed, disposed of.
Obliged.
In primorders, if any, stands vacated.
May I please? Lordship, matter regarding Ex-gratia. In this case, your Lordship, on last occasion, Honorable Court was directed to file amendment procedural, and accordingly on 24 for 2024, we have submitted amendment procedural. Lordship.
Yes.
Yes. Yeah, Lordship, we have implemented the respondent number 5, that is finance. And the fact of the case is that, your Lordship, the husband of the petitioner had expired.
Now, what is this? You have filed applications?
Yes, Lordship.
Before whom?
Before the district legal, the DC of Damaji, your Lordship.
Where is that application?
There is 2 application. One is case number 25 and one is 26 here.
When did the accident happen?
2012.
2012?
Yes, Lord. 122/3/2012.
Yes, who's for the respondent? What steps?
I'm appealing for 2, 3, and 4. So in fact, if at all he is entitled as per this notification, then the deputy commissioner may take a call and dispose of the lordship on that line. Lordship may dispose of them. There are 2 applications. The first application of 2012, then finally he has approached the court, and prior to that, he has filed another application in 2022. But all 2 for 10 years he didn't approach the court. And he hasn't cited any reason why there has been a delay of 10 years in approaching this honorable court.
We have stated.
But you did not make any inquiry. Have you rejected this application on the ground of delay or anything? No.
No.
You see? You have no instructions.
Instruction.
Any instructions?
No. That respect, I have no instruction.
Hard learned.
Lordship, we have made
this
reason of delay
by the petitioner, praying for grant of ex-gratia relief in respect of her late husband, late Lombeswar Borgohain, Elias Lombeswar Gohain, who succumbed to the injuries sustained, which the injuries sustained at an accident while he was riding his motorcycle on number 52 National Highway near the No Ali in front of Bhajugao, Hori Mandir on 22/03/2012 at around 7 p.m. So, pursuant to this unfortunate incident, the petitioner, being the widow of late so-and-so, approached the Deputy Commissioner Dhamati by filing a representation dated 3/9/2012, claiming for ex-gratia compensations. This was followed by subsequently another representation dated 15/3/2022, stated to have been filed by the petitioner. Stop. The petitioner claims that as per the notifications issued by the government from time to time, the petitioner is entitled to be granted an ex-gratia relief as her husband succumbed to the injuries sustained in the road accident. So, the writ petition was filed in the year 2022, and notices in the matter were issued as per Becker's 27/5/2022. However, no response is forthcoming from the respondents. So, today also, when the matter is called on board, the government council is not posted with the required instructions. Accordingly, the court is of the view that the matter need not be kept pending for the want of instructions from the government. Stop. Since two representations are stated to have been filed by the petitioner before the Deputy Commissioner Dhemaji Kumar, the writ petition is disposed of with the direction to the Deputy Commissioner Dhemaji to make necessary inquiries into the matter and call for all required reports from the various quarters as may be necessary. And upon such an inquiry, if it is found that the petitioner is entitled to be paid an ex-gratia in terms of the scheme formulated by the government, as it existed at the time when the petitioner's late husband met with the accident and succumbed to the injuries sustained. The TC will put up a proposal, put up a necessary proposal to be forwarded to the Office of the Commissioner and Secretary, Government of Assam, Revenue and Disaster Management. Stop. The Commissioner and Secretary will thereafter consider the said proposal put up by the DC and pass necessary orders for release of the ex-gratia amount if found to be payable to the petitioner as claimed. Stop. The DC Dhemaji will cause the inquiry to be undertaken, and if found to be correct, proposal be forwarded to the Office of the Commissioner and Secretary, Government of Assam, Revenue and Disaster Management within a period of 60 days from the date of receipt of a certified copy of this order. Stop. If such a proposal is forwarded to the Commissioner and Secretary, Revenue and Disaster Management, then the same shall be considered and necessary orders as deemed fit and proper, as deemed proper, be passed by the Commissioner and Secretary within a further period of 30 days therefrom. With the above observation, the petition stands disposed of and closed.
Deeply.
Yes.
But there are in total 4 matters, out of which I am appearing in 318, 19, and 20. So far, item number 19 is concerned, my lord. We have made an application for amendment of the writ petition. For the reason, my lord, that in the affidavit in opposition submitted by the government, they said that the land which we had referred to in our writ petition is being not taken over by the government. Thereafter, we made an inquiry and we came to learn it's related to, my lord, construction of a flyover and acquisition of private lands, my lord, at Tejpur. So in regard to item number 19, we made search and we also approached the land acquisition authority, and then we came to learn that another plot of land is being taken over. So in that respect, we have made an application, my lord, for amendment. I think the government may not have any objection in that respect. That is in regard to item number 19. So if that has to be amended, my lord, all the methods are analogous and need to be heard together.
Have you filed an application for amendment?
Yes.
In
That
item
is their
19?
IA, my lord. So for item number 19 is done. IA number 1657. It was submitted on 24th of May.
Notice has not been issued in your eye.
This is the first day.
Okay. Will issue notice then in the eye or?
My lord, lordship may be pleased to issue notice, my lord, no difficulty, but thing is that, my lord, we have filed our affidavits in all the analogous matters, my lord. Admittedly and evidently, my lord, it goes to show that they are encroaching upon government lands. Here is a case, my lord, where.
No, therefore we are, if you have any objection, you file your objections here in the eye.
But my lord, they are timing, because my objection will be, my lord, with lordship.
There is an
permission,
interim
yes.
order.
There is an interim order, they are continuing, and my lord, if they have to file a, my lord, they have any grievance, that would amount to, my lord, a separate cause of action, for which they,
Therefore, you file your objections here.
lordship will kindly give a short date, my lord,
Yes.
because they are, our whole project is being stalled, my lord. And our counter affidavits have not been.
Why do you want to amend the writ petition?
My lord,
They can file any, my lord, independent writ petition.
No. My lord, what has happened? I have got 3 plots of land, and the flyover is being constructed over a patch of land, my lord. When we made our first house was marked that this is the land which is going to be acquired. So we mentioned about that plot of land. Subsequently, they submitted their affidavit in opposition saying, no, we are not going to touch this particular plot of land. Then we made inquiry and we found that site, our next land is being taken over by the government. That is what we have amended. Prayer for amendment has been made.
So therefore,
the government cannot deny, my lord, that this land is not being taken over. Initially, they had put mark on a different plot of land, which also belongs to me.
Now, my lord, here, if we go by his submissions, my lord, admittedly, my lord, our affidavit says, my lord, that their land has not been, my lord, touched. So that petition can be disposed of on the basis of, and if he has any grievance that he has another plot of land,
No, side by side, my lord.
That's what, my
Side
lord.
land.
That's what.
They
Then one
could have stated at that time, my lord, that not this plot, but your another plot of land is being.
Have you mentioned the total
Yes, my
number of plots in the writ petition?
My lord.
Where, in which writ petition? 4596?
Yes, my lord.
4596, yes.
Lordship will take up 4597. That is, my lord, item number 19.
Item number.
Apni second, sorry, no?
No, Pradeep. This
Yes,
is-
my lord, it will be 4596. I'm sorry.
4596.
No. It will be 4597, item number 19, my lord.
96,
Yes, 4597.
4597.
Yes.
Pradeep Tebrawal. Now, if lordship is taking up Pradeep Tebrawal, kindly see his prayer portion, my lord, at page number 15. Page number 15. He has, my lord, clearly identified his land. respondents to be restrained to act, not to act illegally in strength of the public notice. My lord, that is the eviction notice which we have issued, my
Now,
lord.
come to para number 2 in the writ petition.
My lord,
You have given a description of the land.
my lord.
Now, is the land in which you now apprehend is going to be
Side
taken?
by side land, my lord. Kindly come to Annexure 5, page 40, my
No,
lord.
has
This
it
will-
been described in para 2?
My lord.
Is it described in para 2?
Initially, it was described in para 2, my lord. Now I am making an application for amendment whereby I am correcting my error because the land situated by side, my lord.
You are not, let me rephrase it. You have more than one plot of land.
My lord.
Have you described given a description of all the lands?
No, only that particular plot of land over which the notice had been pasted, my lord.
Issued, which now they say they are not going to take over.
Take over.
And the alternative plot of land is not described here.
Here.
Is not described here.
Not my.
No, so therefore it will be a separate
But my lord,
repetition.
why this error has occurred, my lord? May I take your lordship to page 40, Annexure 5?
Yes.
The whole incident started, my lord, by a public notice. No individual notice was issued to any of the individual, my lord. And this is the public notice which was pasted on my outer wall, my lord. Now, it is hereby notified to the public that owing to construction of flyover at Mission Charali Tejpur, both the side of National Highway will be extended for the work to be initiated by the PWD. Presently in the said area on both sides of National Highway, there is reserved land for National Highway. It has been noticed that few people have encroached and illegally constructed houses, etc., and have been carrying on business and other activities and thereby using it. Therefore, the said encroachers are hereby directed to vacate the encroached from Purvacharali to Balipukri from the National Highway and land reserved for National Highway. So, a stretch of 7 kilometers has been identified, my lord. No particular person has been named. And what was done, my lord, this public notice was pasted on the outer wall of some of the persons, my lord. So because this notice itself was vague, I mentioned the land over which the notice had been pasted. Now they say that I am not going to touch this land, but side by side they have now marked the another plot of land which is situated by the next plot. And so far the other matters are concerned, the
No, but how do you
item-
say it is marked? By how is it marked?
they pasted
What?
The notice,
No, but
and
the notice
a red
does,
mark was given,
no, notice was not notice does not describe.
That is why it was stayed,
Hmm.
Nothing was described in this particular notice. It was a public notice. Subsequently, my lord, in the month of September 2022, a notice
So
again
if the notice is stayed, then notice in respect of the different plots of land is also stayed.
But I need to correct my pleading, my lord, because now they have pasted it.
No,
on a
because you are
particular-
enjoying an interim order.
They are enjoying, and my lord, that part and
My
first
lord,
enjoying
from
it.
my prayer, I have specifically said, my lord, that if my compensation is calculated and paid, I have no objection, my lord, I will withdraw. Kindly look into the order dated 6th of March, my lord, 2024, by this honorable court. And in any of the matters, there is an order of this honorable court, my lord, which says that admitted compensation may kindly be released.
That is altogether a different matter. They are not taking compensation.
But the other matters are concerned, my lord. They have admitted that some compensation is going to be paid, but nothing has been paid only on the pretext that you people have approached the High Court. Can that be a ground, my lord, for denying me the admitted compensation? And so far, this gentleman is concerned, Pradeep Tibrewala, is another plot of
Who's taking over the land? The revenue
the government
department.
of Assam.
On the where is the requisition? By the National Highway? Is it National Highway?
National Highway is in no way picture, my lord.
It has been taken over by the state of Assam to be handed over to the.
I know,
National
but there
Highway.
has to be a requisition.
Yes.
Where is the
that is done.
requisition?
That is done.
Where is that requisition?
The requisition, my lord, we have annexed, my lord, stated in our affidavit. If lordship is taking up this matter itself. Because that is not the lease before the court. They are only challenging the eviction notice, my lord. They will have a separate cause of action if they are, my lord, aggrieved, if
We
at
have
all, my
challenged
lord.
everything, my
No, no, no. They have mixed up everything, my lord, and the project is now being stalled. It's a project of national importance,
No,
my
my
lord.
lord, in our prayer, we have specifically mentioned we are not opposed to any developmental project, but you have to compensate me. You simply said that you are encroacher. Why it has been said so, my lord? Only to reduce the amount of compensation purposefully.
No, no, no.
That is the only objective.
They
Now,
are
my lord,
getting
another
compensated.
aspect your lordship has asked, where is the construction being made over? It's National Highway number 15. National Highway is in no way picture. Now, if the state government is making the construction of a national highway, whether the National Highway Authority is not to be informed and they are not to be the consent is not to be taken. National Highway Authority Act specifically says it's the central government. But in our state, my lord,
No,
the
no,
state government,
who's constructing the highway?
the state government over the national highway without the concurrence of the central government. This is another aspect which we have raised, my lord. And another important aspect, my lord, is that individual notice has to be issued under Assam Land Acquisition and Requisition Act 1964. No individual notice has been issued. Simply saying that you
No,
people are
therefore, we wanted
encroachers.
to see for what purpose you're trying to acquire the land.
We have raised all these
No,
issues.
my lord, land has been acquired, my lord. Now PWD has, my lord, several wings, my lord. One of the wing is, my lord, National Highway. Now PWD National Highway is now constructing the project over the National Highway. Lordship, for a moment, kindly see the prayer in the writ petition. These are not taken up. Only these are, my lord, afterthoughts. Kindly see, my lord, page number 15 of the writ petition. How they are enjoying, my lord, the stay order.
No, first tell us what land you are trying to acquire. Where is that?
No, Lordship, therefore, my lord, we are going by the individual cases. We have issued a general notice that Lordship has seen.
How can you issue a general notice?
So, general notice, my
You
lord,
have to identify the land which
yes,
you want for your purpose.
absolutely. Now, my lord, that the writ petitioners are before this honorable court, and now that, my lord, the pleadings are exchanged, where we have specifically stated, so far as this writ petition is concerned, my lord, they have specifically pleaded, my lord, that they are the owner of, my lord, two DAG numbers, with 874 and 875. We in our affidavit say, my lord, that we have not touched. If that be the matter, this writ petition can be closed. They are not an aggrieved party. Now they are coming up with this, my lord, IA.
No,
They
no.
say, my lord,
Their grievance is
yes,
that they were under the impression that it is 874 and 875.
yes,
Therefore, they were before this court.
yes.
Subsequently, as per their information, it is not these two ducks, but some adjacent ducks nearby.
So therefore, they will have to file a separate writ petition, my lord, because this writ petition goes, because we will go only by the prayer, my lord. They cannot, my lord, just go on, my lord, developing
No,
their case in this manner.
the essence of the prayer remains the same. They wanted compensation.
No, no,
Unless
no
it is.
compensation. Yes, my lord, let us be clear on it, my lord. Kindly see, my lord, they are not on compensation. Kindly see, my lord. My lord, paragraph, my lord, page 15. Page 15 of the writ petition. Before that, my lord, page 14. Read in the nature of certiorari. Why read in the nature of certiorari should not be issued, and the respondents be restrained to act illegally on the strength of public notice dated so and so, from removing any alleged encroachment of her government reserved roadside land, and to disturb the possession of the petitioner so and so, and another plot of land so and so, found in his possession, or dismantling forcibly without so and so, and in the removal. Nowhere it has been mentioned, my lord.
Continue, my lord.
No,
The
no.
prayer is there.
If you have to acquire this land, then you're bound to give a compensation to the owner or the occupier, as the case may be.
Definitely, we are giving
Now,
it, my lord.
now, if you are not occupying this land covered by these two duck numbers,
yes,
if there was a schedule which you have published indicating the lands that will be required to be acquired for the purposes of the highway, you can point out whether the land claimed to be belonging to the writ petitioner is a part of the schedule. If it is not,
yes.
we can close the writ petition.
Therefore, my lord, in the affidavit, kindly see, my lord, this affidavit has been filed prior to the filing of this IA. After filing of this affidavit, my lord, this IA has come. That is my prayer, my lord. Therefore, I am registering the IA.
No, what is the issue? What difference does it make? Closing this writ petition and bringing another writ petition?
Another writ petition, definitely, my lord. He will raise his own grievance, my lord, because now he is not against the, my lord, eviction notice. He is against, my lord, compensation. He is mixing up everything, my lord. That is my respectful submission. by enjoying a stay order. We are in the receiving end, my lord. Kindly, my lord, appreciate.
Now, come to page number 61 of the affidavit. Annexure 2.
My lord, item number 19.
Sorry,
Item number 19, your
item
lordship is
number
looking
19. Yes, item 19.
Yes,
There is a trace map.
yes,
My
yes,
lord.
lord. We have.
Now, in this trace map, 874 and 75, you say are not to be, according to them, they are
My-
not acquiring this land.
My lord.
Which portion of the land, according to you, is now,
Another dag, my lord,
where is that?
which is there after, my lord. I have mentioned in my IA, my lord.
No, in the
that
trace
is-
map, is it
Trace
visible?
map, they have produced. My
No,
yes.
is it visible in the trace map?
lord. No, it is only confined to that particular dag, my lord. They have not given the other dags which are adjoining there.
We
They
are
have
responding to
My lord,
each
it
of the
will be-
petition, my lord.
If you look at item number 18, my lord, perhaps everything will be clear and my brother will have no say, my lord. That is what he is saying, or otherwise let him submit his reply in the IA. Because there is no sense in on our part,
I
my
am
lord, in
the
filing
whole
one after another
nature and
repetition
character
because
of the
it is
writ
the
proceeding
same.
will change now.
Now, what do you want to point out in item 18?
18, my lord. Here, my lord, item number 18, same reply has been submitted. Here there is no error so far the land is concerned. They say, my lord, in this particular case, that you are an encroacher of government land. What land? The roadside reserve land you have encroached upon.
Yes.
And now they have in their affidavit, my lord, if I can take your lordship to the affidavit submitted by the government, kindly come to
There is a report of the circle officer even, my lord. That lordship will find at page 55 in the
page
affidavit.
55, I am going to refer.
Yes.
May I read or you are going to read?
Please read. It is your petition.
Kindly come to page 55, my lord.
Yes.
With reference to the subject cited above, I have the honor to inform you that Sri Chetan Pansari, who is the Pattadar of land schedule number so and so, village so and so, has been occupying a portion of land that is 5 lassa, which is under road side reserved for national highway. So it gives the impression, my lord, that apart from Patta land, I have encroached a government land from which my eviction has been sought, and therefore there is no question of any compensation, my lord. Now kindly come to next report, my lord, on the strength of which this has been prepared. Page 59, my lord, Annexure 2. Another trace map has been given. And the national highway has been shown clearly, my lord, by a different marking. Now, what is conspicuously missing in the entire trace map, my lord, is every reserve land has to be measured from the midpoint of national highway. Now, the breadth of the national highway has to be given by the government. The government is totally silent. And the government is also silent as to from which midpoint they have measured the particular plot of land in order to identify the
You
enclosed land.
first establish your ownership over this land.
Yeah.
No, they are not disputing the ownership, my lord. They are saying that apart from Patta land, I have
Right.
enclosed a reserve land.
So,
No,
the question is whether it is with regard to the Patta land or is it that reserve land?
that is what I'm trying to impress upon, my lord. Now, this is the map on the strength of which this want to say that you have enclosed a particular government land. Now, this map kindly, for a moment, my lord, look at page 59.
Yes.
Now, your lordship won't find that there is reference of the method adopted to measure the land in order to identify the encroached land, so-called encroached land.
How have you explained in your reply?
I am saying, my lord. So, first of all, this exhibit, this page 59, annexure 2, my lord. The law says, my lord, that from midpoint of national highway.
How are you concerned with that?
I am just
first you have to establish that this land which is shown is a land which has been given to you by proper meets and bounds, and you have proper documents.
I am within my Patta
On
land.
what basis are you saying that?
I am within my Patta land, my lord. Let me show. There are 3 things that I would highlight, my lord, in this respect. Now, kindly come to next page, my lord. Thereafter, I will come to the question that your lordship has put. Page 60, my lord. Again, the sketch map has been given. Your lordship won't find any sort of breadth and length. Breadth is very important, my lord, and why I am saying
You're
time and
going
again, my lord.
around, you're skirting the question of the court. We want to ask you the land which
Okay,
you
but
think
let me
is
answer that
under your
first.
possession. You show us.
Let me answer that first, my lord.
Yes.
Kindly come to my affidavit, further affidavit in reply, and more particularly to page 79, my lord.
$79, yes.
My lord. This is Annexure 7, my lord. During the pendency of this writ petition, I approached the authority, my lord, for conversion of my land. And the authority did not find any chunk of land within my possession whereby they can say encroacher. And my land was ultimately converted, my lord, from residential to commercial. This is during the pendency of the writ petition, my lord. Now the same government is saying in the affidavit that I am an encroacher, and the same government is converting the land from one class to another, saying that I am a good man. Same plot of land, my lord. This is nothing but dual standard of the government, my lord. In one breath.
Where
This-
in
kindly come to page 82,
in the
my-
trace map, where is that portion of your land? Page number 59 or 60. Where is this land which you have referred to at page 70?
This is the same dag and patta, my lord.
Where is that?
Your lordship asking for dag and patta.
Is it reflected in the trace map?
Yes, my.
Yes.
If your lordship look at page
559.
559 and dag is 1153. Same dag, same patta. I don't have any other plot of land. And the government has also admitted through their affidavit in reply, my lord, that there is a shop which belongs to me and where from I am doing business. And that is the reason, my lord, which prompted the government to reclassify the land. Now, if I am an encroacher, my lord, whether the government is going to reclassify the land, when everything was found correct, my lord, only then the reclassification was done by the same department, same revenue department.
No, reclassification and measure of land.
So they
which
found the measurement correct, my lord, then only the reclassification was done. The government cannot say that reclassification was done, the horse, the illegal possession, my lord. I was found in correct possession, only then reclassification
That
was
is a
accommodated.
presumption. That is a presumption you are trying to
No,
do.
no, my lord, that is my humble submission, my lord, based on law.
Yes.
Lordship, kindly see. Lordship, attention has been now just drawn to my lord, page number.
Was there any report by the circle officer in
Yes,
this
yes,
page 79
yes,
prior
yes.
to issuance, prior to reclassification?
Yes, kindly see, my lord, because here now petitioner is concerned with tag number 1153. That lordship will kindly see at page number 55. Kindly see, my lord. This is a translated copy.
Yes.
Now here we are concerned with, my lord, tag number 1153. So far as, my lord, this writ petition is concerned.
Yes.
Of periodic patta number, he is a recorded pattadar. Absolute honor, no denial to that fact. But he has, my lord, extended his
over and
occupation.
above.
Yes,
Over and
over and above. He has, therefore, this marking assumes significance, my lord. Page 59 and page 60. Kindly see, my lord. I am holding page 60 for a moment, my lord. Kindly see. My lord, this is the trace map. This is the national highway. And over the national highway, there is a black, my lord, marking. This is the black marking. Their land, their own patta land is situated by the side of the national highway. no difficulty. If they are permitted to, my lord, reclassify it to a commercial land, agricultural, industrial, whatever, my lord, they are the absolute owners. Of course, my lord, within the parameters of law, they can enjoy the fruit of that land by enjoying possession. They have, my lord, extended their occupation. Thereby, they have transgressed into the national highway. This is where, my lord, the difficulty lies. And they are seeking to say, my lord, that since it has been reclassified, so their illegal occupation also needs to be ratified by the government, which cannot be done under the law.
So I think you need to file a fresh writ petition.
Absolutely.
Kindly come to page 59 and 60 once again. That is why I was trying to show, my lord, why the measurement has not been given purposefully.
That's a different subject matter.
But my lord, that
You
needs
cannot-
to be
you cannot.
adjudicated.
You can
May I refer to
you
my lord?
you may urge this. That's a different subject matter.
My lord, this is, we are looking at item number 18. Here, everything is clear.
Here
Item
everything
number
is
18.
clear, but in the face of the affidavit which is filed, where there is a
But their affidavit cannot be taken as gospel truth, my lord, since it violates Rule 69. May I take your lordship attention to Rule 69 of
but
Assam
their
Land?
affidavit has very categorically held that they do not want that particular of land which according to you is required for construction.
No, my lord, let me show your lordship that whatever I possess, my lord, is within my patta land. Now, if the government says, my lord, that I am
You wanted to file an IA where? In item
in
19.
item number 19.
So 19, we can close it. 19 has got no connection with 18.
No, all are interlinked, my lord.
No.
Same.
Your
my
item number 18 is specifically with this DUG number 1153.
my lord. Item number 18.
This will keep it, we'll hear this matter.
My lord, but so far item number 19, because ultimately it was a public notice, no specific notice, my
Whatever
lord.
it may be,
Now-
the categorical stand that they don't want, we'll record that stand. And we'll close it. If there is
My
a
lord,
further grievance, you
but
can always
the
come back.
same notice has been now pasted on my other one. So, side by side, let me have.
It can't go on, you cannot go on amending
But
it.
my lord, the behavior of the government also needs to be taken because they pasted on another
We'll
one.
examine it in item 18. We'll
My lord,
examine
but-
that your
but
specific prayer is there,
The
that you are on the land covered under DUG number 1153 and PP number 5590 so and so, and any forcible removal or dismantling has to be done as per the provisions of
As
law.
per
You're
provision of-
concerned about
So
that.
far, item number 19 is concerned, my lord, he is a different applicant. He is having the land side by side. All the three are side by side. So
That's
far,
right,
18,
but the
19,
government
20.
affidavit is very clear that they don't want that part of the land.
My
We'll
lord.
record and close it.
My lord, but
Why do you want to seek an amendment here? For what purpose?
ultimately it will nothing but a cumbersome job, unnecessary, my lord, because
What cumbersome?
cumbersome in the sense, my lord, the Honorable High Court is seized with this matter.
Right.
The affidavit is already on record. Whether in the IA they are going to deny whatever I have made the allegation, my lord, that the side by side plot of land is being now taken over. Initially, the government had put the notice.
What is that side by side plot of land? Where have you indicated that?
I have mentioned, my lord, in my IA. Let them deny first, my lord, because they don't want to file the affidavit. If they file the affidavit, thereafter, if your lordship comes to a conclusion that this IA cannot be taken together along with the writ petition, I have no issue, my lord. Let them submit their affidavit on oath.
He cannot compel.
No, this is my prayer, my lord. I am not compelling it.
Where have you stated that? In the IA?
My lord.
In the prayer portion is absolutely, my lord, vague. Kindly see, page 10, paragraph 9.
May I read first? 6. You continue. My lord, IA.
Yes.
May I take your lordship to para 3. This I am reading from 7th line, my lord. The state respondents are to show as to under what law the construction has been undertaken in the name of the public interest. Further, they claim that the public notice dated 1/7/22 was issued on the alleged encroachers cannot be justified since the government cannot show having done any survey identifying the alleged encroachment of the land till then. The survey is supposed to be done with the help of the circle officer of the concerned circle. The concerned circle office is the Tejpur Revenue Circle. This writ petitioner had, I'm reading from another writ petition, my lord. Oh, sorry. I'm reading from 4596. Let me read from 4596. My lord, para 2, IA. Respondent number 2 has submitted an affidavit in opposition in the writ petition. From a reading of the same, it becomes clear that the government is not going to acquire or even touch the land in question in this writ petition, though the land in question was the one where the state authorities had initially put marks and pasted the public notice dated 1/7/22, which prompted this writ petitioner to challenge the notice. After having gone through the affidavit in opposition filed by the government and observing that the revenue official of late have been measuring another plot of land of this petitioner, where his family members have another business establishment. It is worth mentioning here that this writ petitioner and his family members have many lands and other businesses other than what has been referred to earlier in the writ petition. This writ petitioner has a plot of land that he owns along with his two sons, so and so, so and so. This land also falls in the same area where the flyover is being constructed and where other lands of this petitioner as referred to here in above in the writ petition falls. The land that this petitioner is talking about measures 1 kattha 4 lassa and is observed covered under dag number so and so, patta number so and so. The land is situated at village Gotanga Kahtal, district Sonipur, Assam. This petitioner along with his two sons. So here, my lord, in para 2 and thereafter, my lord, para 4.
This is an entirely different
But there
subject
itself, my
matter.
lord, there itself, my lord. Now let the government say, my lord, that they did not paste it on the
You file a proper writ petition, they'll say, you file it. We're not stopping you from filing it.
My lord, what they are going to do, whosoever has not filed, in the meanwhile, they have demolished everything, leaving no mark of its existence, my lord. Now, we have no objection, my lord, to any developmental project. In our writ petition itself, we have said so, my lord. But not in the fashion in which the government is proceeding. Somehow they want to make the construction over the national highway, whereas the national highway authority is not in picture, the central government is not in picture. The
Where
land
have you-
acquisition, my lord.
Where have you raised these objections?
This objection I have raised in all the cases, my lord. If your lordship is looking at IA,
Not in the IA, in the writ petition?
if I am to read item number 18, my lord.
No, item 18, we're convinced we'll have to hear it.
No.
Item 18, we'll hear it. We're talking about item 19, where you are seeking an IA for amending the writ petition.
My lord. In the IA
By
itself, we have mentioned, my lord.
changing the
In the IA itself, we have mentioned, my
particulars
lord.
of the land.
Yes, my lord.
Then,
in the IA itself, we have mentioned about it. Now, may I?
Mr. Counsel, we are not convinced that this IA should be permitted, although you have a right for amendment, but,
But my
instead
lord,
of
let
amendment,
them submit their affidavit. If they say, my lord, that this land is also not being touched, I have no cause, my lord. So instead of filing another writ petition, going for another round of litigation, if they say that they are not going to touch this particular plot of land, I will withdraw my writ petition. Why to file another?
no, the very basis of this item 19 relates to a completely different plot of land.
My lord, I understand. But if
Then
the
your whole grievance, your whole anxiety, the allegations are with regard to that particular land.
My lord.
Now you simply want to change that land and bring some other land.
That is why I am time and again requesting my learned brother and the government to respond to this. If they say this land is also not being touched, my lord, which is going to be touched? If they say that they are not going to touch, my lord, why I should file another writ petition? I will withdraw simply.
Which means, as on date, there is the entire.
But they have marked, my lord. No, my lord, they have marked. Let it be fixed on after 3-4 days, my lord, if they respond in the meanwhile. We are also not interested.
We are not inclined to keep this
My lord,
pending.
kindly fix it on 3-4 days, my lord. Let them respond to it. Because ultimately your lordship was also
We can't
saying
compel
that
them to
withdraw
respond. If they want to respond, they'll respond. But we are not issuing notice yet. You are not issuing notice in this IA. This will,
My lord, I humbly pray,
this
my
will
lord.
change the nature of the pending writ petition.
No, my lord, everything will remain the same, save and except
Now
the
how?
plot tag and patta number. My lord, I am the owner. I am not asking
You
for.
may be the owner, but what constructions do you have on that land?
My lord, if they are not touching my land,
What constructions do you have on the
there
land?
is a business running, my lord. Kindly come to page, para 3, page 6.
So all these particulars, you'll have to change it. You'll have
Only,
to bring it every detail on record.
my lord,
When your earlier writ petition was premised on the different set of land,
my lord,
with the apprehension that this land will be taken over.
the business is same, my lord.
Maybe you're
Well-
filing a writ petition with a specific prayer.
The prayer will remain the same, my lord. My lord, let them
That is
respond.
as
If
good
they
as
say, my
saying,
lord, my lord.
Mr. You're a senior counsel, you know that it's as good as saying that we have filed a writ petition, therefore in respect of us, no land should be.
My lord, am I wrong, my lord, if I am saying that if they respond and say that this land is also not going to be touched, my
No,
lord?
no, if they respond with to the contrary, what happens? They may respond that yes, this is the land we require. Then
Ultimately, fact remains, my lord, that everything was initiated on a public
Mr.
notice
Counsel,
without having
Mr.
any
Mr.
specific.
Counsel, please understand. You are inviting a response from them to say that this land will not be touched. What if it is the contrary? What if they say that yes, this is the land we require?
Now, my lord,
Then
your lordship will appreciate.
until and
that-
unless we allow your amendment petition,
My lord,
we can't grant you any interim orders. Ultimately, if your land is affected, you are
My-
praying for an interim order. So you come with a fresh course of action with a proper writ petition, expressing your apprehension.
my lord,
If required, we'll give you protection.
may I say something? Kindly look at Annexure 5, my
Of
lord. Annexure 5 of my writ petition. Ultimately, there is no dispute that this was a public
item 19.
Item 19. This was the notice, my lord, which was totally vague. And on the strength of this notice, everything is continuing till date. Now, my lord, is there anything to indicate that this particular plot of land is being taken over from my...
Then why are you apprehending?
But my lord, it was pasted. And ultimately, they admit, yes, it was pasted. But this plot of land, we are not going to touch.
So if you're apprehending,
same-
you bring a fresh cause. This is a fresh cause of action.
My lord, but the notice remains the same.
If this apprehension was there
My lord,
when you filed this first writ petition,
my lord.
it would have been mentioned there. You would have prayed for protection with regard to that land. Subsequently, you have come to realize that this is not the land which they want some other land. Does it not give rise to a fresh cause of action?
The notice remains the same, applicant is the same, the land remains side by side. If they say, my lord, in response that this is the land also not going to
No,
be
if they say to the contrary that yes, this is the land we require, what orders do you perceive we pass in your existing writ petition? What orders do you want us to pass? Unless your prayer for amendment is allowed,
my lord.
what orders do you want us to pass?
But similar,
We can't we can't give you any effective orders
my lord,
because the subject matter has changed.
I can understand, my lord. So far, item number 20 is concerned, same had happened. The amendment petition was allowed because of their concurrence, my lord.
Now they are not concurring.
Item number 20. Item number 20, my lord. And the amended writ petition has been filed and they have responded to that also. They are analogous matter, my lord. Kindly look at
Well, it
item
is,
number 20.
if you insist that yes, it needs to be done, we'll
I
proceed
only
with the
pray, my
matter. We
lord. I
don't
can
know.
pray, my lord. I cannot insist. I only
But
humbly
as
pray,
on date,
my lord.
please be wary of the fact that as on date,
My lord.
there is no interim protection in respect of the land that you are seeking apprehension. You are apprehending today.
I understand. My lord,
There
just
is no interim
for
order. We
another
can't
phrase,
we cannot extend the interim order passed in respect of a separate plot of land to cover the land in respect of which you are now apprehending.
is there anything, my lord, on their part to respond to this within 2
It is
3
for
days?
them to respond. We are hardly restraining them to respond.
Let them, my lord, if your lordship so pleases, let them respond. Kindly fix a date on 26th or whatever is convenient to my brother. I am not asking for any date after vacation, my lord.
All right, you file your objections if you have. We'll decide on the IA.
Yes, my
We are not convinced that the IA should be allowed at this stage. Yes, it is true that you can seek an amendment at any stage. But for what effect?
objection, my lord.
What you are seeking let me spell it out for you. You are seeking this amendment to have the continuation of the interim order in respect of the land which you now apprehend. An interim order which was passed in respect of the land in which now they say they don't want to
My
proceed.
lord, may I say something? The interim is as regard to Annexure 5, which is a vague public notice.
Correct. That vague public's notice is not applicable to the entire state of Assam. You are apprehending in that it is applicable to you without disclosing the details of the land which they require.
Right.
Correct.
Right.
So if that be so, your interim order passed under item 18 will cover your apprehensions today. The insistence on seeking an amendment until the amendment is allowed, how can we extend the benefit of the interim order to this land?
I hope
Which we may consider if you come up with a fresh writ petition.
I
Matters be listed next week. The respondents are at liberty to file their objections. If any, we are not issuing notice.
Lordship may kindly, if my lord, please, yes, my lord. One aspect of the matter, even in the amendment application, there is not specific. They are taking everyone for a right. Kindly see, my lord.
You file your objections, we'll take it up.
Otherwise, not all the writ petition goes, my lord. We have filed detailed affidavit. Lordship may be pleased to fix a date, my lord, in that case, my lord. Any date
Can it be on
subject to my lord.
26th?
We'll see on 18th, if possible. 18th of June.
18th of June, yes, my lord.
18th of June.
18th of June, yes. Yes.
If it is possible, my lord, on 26th. On 18th, 19th, I have some personal difficulties, my lord.
26th.
My lord.
26th, I don't think it will be possible. It's the last week. In the week beginning from 24th, it will not be possible. Or it goes to July. Hard learned council for the parties. The respondents are at liberty to file in the IA, you write, IA in item 19. Respondents are at liberty to file their objection, if so advised. Matter be listed for admission hearing. You can have it on 19th if you want.
Well, can it be on 21st, my lord? 21st. My lord, then let it be 18, my lord.
19th, I hope I have.
19th of June.
On so and so date, yes. You agree on the date and supply it to the court master.
Lordship, only one prayer, my lord. My lord may be pleased to observe an attempt will be made to dispose because pleadings are complete, my lord.
What is the purpose of the observation? You press for a hearing,
My lord.
we will ensure that this attempt gets into a reality.
My lord, we are always ready, my lord, but every time some sort of.
So, have you agreed on a date?
19.
19. Obliged. June.
I'm so obliged.
Mr. Biswas appears for item 21.
We also make notice that you have controlled the land and.
We'll take it up on 19th.
His case is also arising out of the same notice, my lord. We have also exchanged our pleading. I'm obliged.
Lordship, as per the last court order, we are supposed to file the measurement book, Lordship. Here. We have marked the name of the contractors who has been awarded who has to perform the work. And the name
So
of
what are we supposed to do examining your measurement book? Why are you not bringing it on by way of an affidavit? You disclose whatever is there.
Lordship, we have already filed, Lordship.
So then, have you given reference?
Lordship, regarding this one, Lordship, we have already stated.
What is there in the measurement book?
Lordship, last court order, it has been directed us to produce a measurement book for from whom it can be verified whether the petitioner had performed the work or not.
Have
As
you,
per, as
Ye-
per our stand, Lordship, Water Resource Department stand, although petitioner has been given the work order, but he has not performed the work, Lordship. He has not done any work, because of which payment could not be made to him. He has come to this honorable court to release his payment, Lordship, against the work order.
show us from the measurement that
Lord-
work has not been done?
Lordship, I have flag marked the name of the other contractors. All the contractors' names has been flag marked, Lordship.
How do you identify this work done by X contractor and Y contractor? How?
Lordship,
Where are the particular?
their name has been written in the measurement book, Lordship.
So these names are written by in your flag mark. In the measurement book, I don't see it is written. You allow your friend to go through it.
Lordship, I will.
What is this?
Departmental letter.
Huh?
Departmental letter, departmental. Start my work, Lordship, I not complete. Then they acknowledge me within 7 days I can complete. Then I complete it, Lordship. Page 19 photo is also there.
You go through the measurement book, they say it is not there.
Whether they right or not, we don't know. Where the departmental.
Lordship, name of the contractors are there, Lordship, against the name, Lordship, here.
You show it to him. You verify, examine and pay, that's it.
Lordship, we have verified, Lordship.
Huh.
He has not completed the work because of which
Is there any completion certificate
nothing.
enclosed to the writ petition?
Small what they do not give any complete certificate.
Nothing. So if in the face of their
Lordship,
dispute,
another case, Lordship, also disposed in by court. Lordship.
no, but there has to be an admission.
Same
Lordship.
measurement. He had given 500. I have given 500. 500 meters.
Is there any statement here that it has been
Just court
it has been admitted
no
by the
liability.
department?
verify the petitioner complete the work or not. If he complete, they can provide.
He has already said he is not completed. This is their stand.
Yes, Lordship. In
Departmental
record,
letter is there, Lordship.
This letter says you are required to complete. This letter says you did not complete.
Then I complete, Lordship.
So on what basis? That photograph,
Photo.
we are not here to examine your photographs. You go and file a civil suit. Go and file a money suit. You produce all these photographs and all evidences that you have. You produce it. How do we decide on the face of contesting arguments?
Maybe directed them to if they verify it and if complete.
They have
can
already
give.
made
Also,
a
if not
statement
complete,
that they
then
have,
dismiss.
on instructions, he has stated that you did not execute the work.
Lordship.
Have you stated in your affidavit?
Yes, Lordship. Paragraph 8, Lordship.
They've already stated here. There are no records available.
The starting point, Lordship, we have given 500 rupees to deposit in department.
You may have given.
500, 5,000 rupees. 5% should be deposit. After deposit, whether I can.
He had participated in the tender works, Lordship. That is not denied.
Page
Lordship.
15, Lordship, I also annex.
They also
Whatever
admit.
document is in my hand, I also annex.
They also admit that you have deposited earnest money, and they have given you liberty to withdraw the
Not a
earnest money.
single money they give you 5,000 rupees is also I lost.
Mr. Counsel, in the face of disputed questions of fact, we cannot issue a writ. We would not like to issue. If there is an admission that yes, some work has been done, some payments are due, we could have directed, disposed of the writ petition with a direction. There is a categorical denial that there is no work done. When was the contract issued?
It's written in our application, Lordship.
Work order was allotted in 2012.
12.
And you have come to court in 2022. So we dismiss or you withdraw?
Their affidavit just said no record is available.
That's right.
But my petition page 15, what about that stand item?
Page 15.
Page 15, okay.
What
I
have you
already
stated?
deposit 5,000 deposit.
That we have admitted.
That they have said in their affidavit.
Uh,
Para number 7.
7, Lordship.
Para 7 they've said you've deposited, you're at liberty to withdraw it.
Let me chance to withdraw this money also.
They have.
We have already given it.
They've already stated you can withdraw it.
Okay. That's let me.
Heard learned counsel for the parties. This petition is filed by the petitioner, seeking direction to the court for release of his bills for works executed respect of within courts construction of FE along LB of River Digaru from National Highway to Kurkuria Hill under the Water Resources Department. Stop. Learned counsel for the petitioner submits that the petitioner was granted, was issued, was allotted the work order. Here is the work order dated 2/3/2012 for the so-and-so work order, construction of so-and-so, page number 60. Stop. In pursuance to the work allotted, the petitioner deposited the earnest money as required. Stop. The petitioner claims to have completed the work, but the bills raised for completion of the work amounting to rupees 2,43,412 with interest has not been paid against the works executed. Stop. Being aggrieved, he is filed the present petition parent. The respondent have filed an affidavit stating that uh, uh, making a categorical averment that there are no records available in the office of the Executive Engineer, Guwahati East Water Resources Department in the district of Kapluk Metro in respect of the works undertaken or completed by the petitioner. Stop. The respondents, however, state in their affidavit that against the work allotted, the petitioner had deposited 2% of the tender amount as earnest money in favor of the executive engineer, and which the petitioner is at liberty to withdraw anytime from the said office. Stop. in view of the disputes, disputed question of fact raised this court by the earlier order dated 24/11/2022 directed the respondents to produce the measurement book. Stop. Learned Standing Counsel has produced the measurement book before this court. Para. Having heard learned counsel for the parties and upon careful perusal of the pleadings on record, it is seen that the respondents have not admitted to the execution of the works undertaken by the petitioner. Stop. The respondents admit that the petitioner has been allotted the work and he had accordingly deposited the this money as required, but the works allotted were not executed by him. Stop. Therefore, not allotted to. He is not. The payments claimed cannot be released to him. Stop. The measurement book produced before the court and as pointed out by the counsel for the respondent does not show the work executed by the petitioner have been recorded in the measurement book. Stop. Although the affidavit filed by the respondents reflect that petitioner, although allotted the contract work, did not execute the same. However, the affidavit does not bring on record as to whether the said work was subsequently required to be executed by issuance of a fresh tender or by allotting the work to some other contractor. Stop. Or even that the work was never executed. Stop. It is also seen that the respondents have admitted that the work was allotted to the petitioner, but he failed to execute the same. And at the same time, they state that the petitioner is at liberty to withdraw the earnest money from the office of the executive engineer. Stop. Para. Having heard learned counsel for the parties and upon careful perusal of the pleadings on record, it is seen that the work stated to have been executed by the petitioner is not admitted to by the department. Stop. The measurement book produced before the court also does not reflect any measurement of works stated to have been executed by the petitioner. Stop. What is, however, noticed is that there is no particular in the affidavit before this court as to whether the work allotted to the petitioner was executed through some other contractor or was it abandoned. Stop. If the work is allotted to the any contractor, ordinarily as per the law of contract, the earnest money on the failure of the contractor, the earnest money is forfeited. On the failure of the contractor to execute the contract, or in the event the contractor abandons the work after being allotted, the earnest money is forfeited. Stop. However, the affidavit clearly reflects that the petitioner is at liberty to withdraw the earnest money from the office of the department. Under such circumstances, this court deems it proper to direct the chief engineer, water resources, to cause a proper inquiry into the claims of the writ petitioner. And if the writ petitioner is entitled, had executed the works allotted to him or had partially executed the works, then any payment payable to the petitioner in terms of the contract uh, shall be released after due and proper verification of the same. So the entire exercise be completed by the Office of the Chief Engineer within a period of 90 days from the date of receipt of a certified copy of this order. Writ petition accordingly stands disposed of in terms of the above.
Deeply.
Okay,
we are implemented as respondent number 7, AP detail. We need some time for instructions.
Yes.
okay,
Standing counsel for APDCL prays for further time to complete his instructions. Prayer made is not
Lordship,
objected
the
to.
petitioner may be directed to submit, furnish extra copies. There was a direction on last occasion.
The
He has not furnished extra copies.
matter be listed after 3 weeks. Meanwhile, the writ petitioner will furnish extra copies of the writ petition to the standing counsel if not already furnished within a period of 1 week from the
Alright.
list accordingly.
My lord, this matter is impetuous, my lord, already the
Is
Rest of
submitted
the-
by Mr. A. Chaudhary, learned counsel for the petitioner. Writ petition stands dismissed as infractuous. Mr. N. Goswami appears for the
all the
Yes.
respondent.
all the respondents. The interim orders, the hearing stands vacated.
May I please your thought, Lord? This matter became infractuous, Lord.
It is submitted by Mr.
U. Sharma. I am appearing on behalf of H.J. Sharma.
Mr. U. Sharma appearing on behalf of Mr. S. Sharma that the writ petition has become infractuous and therefore the petitioner does not wish to press the same. MS so-and-so appears for the bank.
Bank, yes, Lord. On behalf of M. Sharma.
Is on behalf of Mr. M. Sharma for the bank. Accordingly, writ petition stands dismissed as infractuous. Interim orders, if any, stands vacated.
Cholan.
May it please your lordship. My lord, in this case, my lord, the petitioners, my lord, he's running this, he's maintaining the Muchi Kabrastan, my lord. This is a Viheta Jwati Ravidas Muchi Samavadi Union Sanghasa, my lord. They are maintaining the Muchi Kabrastan, my lord. And it has been encroached upon by some of the encroachers, my lord. An affidavit to that effect has been filed, my lord, by the DC, my lord. I will take a lordship to the affidavit, my lord. Filed by respondent number 3, my lord.
Yes.
To paragraph number 4, 5, and 6, my lord. It is an admitted positions, my lord. That, my lord, it has been encroached, my lord. Then under the regulations 18, my lord, of the land revenue regulation, my lord, settlement rules of the land revenue. This can be directed to evict them. Page 76, my lord, para 4. Affidavit in opposition, my lord.
Yes.
With regard to the statement made in para 6, the opponent says that as per the available records of the land records, land measuring 1 bigha 4/3.7 lesser covered by DAG number 2140 of village, so in a part 2 under Lubari Maja, is government land and is recorded in the name of Muchi Kabrastan. On the other hand, land measuring 9.8 lesser under government DAG number 2142 of same village of Moja is also recorded as Muchi Kabrastan. And also land measuring 5 bigha 1 kata 13.8 lesser under government DAG number so of village and Moja is also recorded as Muchi Kabrastan. Again, the land measuring 1 bigha covered by 214 of the same village of Moja is recorded as a road. Theta copy enclosed. During field verification, the plot of land under government DAG number 2141 is seen as road. With regard to para number 7, the deponent stated on spot verification of the lot model staff, the plot of land DAG number 2140, 2142, 2145 of the same village is running as Muchi Kabrastan. With regard to para number 10, deponent further stated during field verification by the lot model staff, it is seen that the plot of land DAG number 2140, 2142 and 2145 of the said village and Moja is possessed by some people by constructing Tin Chali house, and some part of the land is possessed by Star Sports Club by constructing Assam type house, garage of Nanki Ram, Muslim gas and commercial establishment of Rafiqul Islam. So some part has been encroached by some of the encroachers, my lord.
So, my lord, since this is a land reserved for the purpose of Muji Kabastan, my lord, so I make a statement in my paragraph, in my petition, my lord, regarding my lord, rule 18.18, para 17, my lord. There are judgment to that effect also, my lord, just passing judgment and judgment of this honorable court, my lord. Whereby it has been held that, my lord, if the land is been encroached by the encroachers, my lord, which is reserved for particular purpose, my lord, then no notice is required to be sent, my lord. The DC can directly evict them from there.
That is on a government land.
Is not here. Yes, is a land reserved for this particular purpose, my lord.
You say,
Yes, well, I will take your lordship to.
In your affidavit, lordship, there's some encroachers are there, lordship.
remove them.
Lordship, by sending them notices, lordship.
I don't know what steps you want.
Lord.
You are the custodian.
Yes, my lord, they are the custodian, my lord.
And they have filed one, lordship, page 68, lordship. They have filed one application before the deputy commissioner also, page 68, lord.
Who are the writ petitioners?
Writ petitioners, my lord, I have enclosed, my lord, the copy of the registrant certificate of the society, my lord, and the memorandum of associations, my lord. Lordship may kindly come to annexure 1, my lord, page 21, my lord. Page 21, my lord. And the memorandum of associations, my lord, lordship will find at page 25, my lord. This annexure 2 is the resolution that has been adopted by the society, my lord, for filing a case before the Honorable High Court, because they have submitted several representation to the authority, but that has not been taken care of, my lord. And page 25, lordship will see the memorandum, my lord. 6 may be kindly be seen objective, my lord.
20?
Page 25, objective number 6, my lord. The Sangam means the organization has been established basically for the management, maintenance, achievement, protection, and development of Ravidas Muchi Samradhi, and their all their institutional properties like Ravidas Muchi Kabrastan and such other institutions, my lord. This is the management, my lord, which is running after running the society, my lord. Running the Muchi Kabrastan, my lord. This is a society, my lord, which is representing the Muchi community, my lord. The notification to that effect by the government, my lord, of 1981 and subsequent also, my lord. That eviction operation should be done, my lord, on priority basis where land is reserved for particular purpose, my lord. I have annexed that notification at page 53 also.
Yes.
I will take your lordship to one of the judgment, my lord, which of our High Court, my lord, 105 to 2018, my lord. I will take your lordship to para number 25, my lord.
Yes.
Para number 25. This is also similar case, my lord, where some persons have been.
If you want to take us through a judgment, take us properly. Tell us what is the facts in the judgment.
Yes, facts is, my lord, lordship will, my lord, in this case, my lord, these petitioners, they have been holding up government land, my lord, for long durations, my lord, and thereafter they have approached this honorable court, my lord, for a direction that they should not be evicted, my lord. So thereafter, my lord, the regulations 18 of the settlement rules, my lord, as well as 16 has duly been considered by this honorable court, my lord, that begins from para number 16, my lord. That begins from para number 16, my lord.
Yes.
Para number 16, then I will read para number 16, my lord. 16, my lord. As the matter of eviction in relation to government land is to be undertaken as per the provisions contained in Rule 18 of the settlement rules framed under the Assam Land and Revenue Regulation, it is opposite to refer the relevant part of Rule 18 hereunder. Then ejectment, my lord. This is the rule, my lord. Subject to hereinafter provided, the Deputy Commissioner may eject any person from the land over which no person has acquired the right of a proprietor, landholder, or settlement holder. When such person has entered, number 2, my lord, when such person has entered into possession of government trust land, west land, or east over which no person has acquired the right of proprietor, landholder, settlement holder, or any other right that has previously been reserved road or roadside land, or for grazing of village cattle, or for any other purpose, or has entered into possession of land from which he has been excluded by general special order, and when further there is no bona fide claim of the right involved, he may be ejected or ordered to vacate the land forthwith, and the Deputy Commissioner may sell, confiscate, or destroy any crop raised or any building or other construction erected without authority on the land. So thereafter, Rule 16, my lord, of the settlement is also relevant for the case in hand, that there, and the same read as under prohibitions to enter into land until issue of lease. Lease shall issue on written applications only, and no person shall enter into possession of waste land in any area until a lease has been issued to him, or otherwise a written permissions by Deputy Commissioner has been granted to him, pending issue of such lease to enter into possession. So this is the rules, my lord. So the next I will take your lordship to page 25. That is relevant to our case also, my lord. This was
Yes.
page 25, my lord.
Hmm.
In this case, this court in WPC 615F 2019, Taharali versus State of Assam and others, took into notice the amendment carried out in the year 1997 in the sub-rule 2 of Rule 18 of the settlement rules with effect from 21/3/1997, whereby it was inter alia provided that the encroachers of the government land who did not have any bona fide claim over the land can be ejected from the land forthwith. The amended sub-rule 8.2 has expressly omitted the provisions for issuance in eviction notice upon the encroachers. By referring to the decision of Pundargaon Anti-Eviction Action Committee Supra, this court has observed as under. Paragraph 15. From the above, it is clear that amendment provisions of 18.2 of the settlement rule does not mandate issuance of any notice upon the persons coming in ambit of the sub-rule. The petitioners are admittedly in unauthorized occupations of our Sarkari khas, and it is evident from the material on record that they do not have any bona fide claim of right over such land. Such being the position, there was no requirement under the settlement rules for the authorities to serve any eviction notice upon any of the petitioners. Notwithstanding the same, the respondent had served the notice upon the petitioners, granting 15 days time to vacate the land, thereby complying with the principle of natural justice. Reverting back to the fact of the case in hand, it is already noticed that the petitioner have failed to show any kind of document that they have any bona fide claim in any part of the land of measuring so and so, falling under so and so, so and so. The revenue record goes to show that the plot of land covered by so and so has been recorded as a government trust land, and the same is reserved for road. This is the case where reserved for road, madam. Not suiting the claim of the petitioner regarding possession or any part of the said land, the petitioner have been found to be in possession of the said land without any kind of permission of the respondent authorities, and as such they cannot be termed in any other manner other than encroachers. The allegations against the petitioners are that by encroaching upon the said plot.
Have you made these persons respondents in the writ petition?
No, my lord. This is not required in this case, my lord, because this land is specifically reserved for, my lord, reserved for particular purpose, Kabristan, my lord.
So therefore, the proper finding has to be arrived at by the DC.
Yes, my lord. We have made a representation of DC. DC has to take care of, my lord. In the initial order, my lord, there was a directions, my lord, that pendency will not be a bar to consider our representation, but that has not been considered, my lord. So now, since it is an admitted position, my lord, that they have been encroaching, my lord. So in view of the rule, settlement rules 18, my lord, lordship can direct, my lord, to take a proper necessary steps to evict them, my lord. Because 18(2) is very clear, my lord. If the land is reserved for
That will,
particular purpose.
see, a direction will require the parties to be present before the court. It is your claim that they have no authority.
Yeah.
But at least they should have been made respondents here. You know who are there on the land.
Then DC can take care of the matter.
We can do it, then we can't direct the DC to evict. We'll direct them to take proper steps under the provision of the rules.
Yes, ma'am.
Yes.
Lordship.
Her turn is complete for the party to be the claim of the petition. That they are a what? Society.
Yes, my lord.
They are a Sangha, namely Brihotar, Guwahati, Ravi, Das, Munshi, Sampraday, Mushi, Sampraday, Unnoyan, Sangha. It is a society registered under the Societies Registration Act, bearing registration number so and so, paragraph 1. Number 2 is the president of the society and the present Mahant of the Muchi Kabristan at Guwahati. Petitioners number 3 and 4 are the working president and secretary, general secretary. Petitioners number 2, 3, and 4 are all members of the petitioner number 1 society. And they belong to the, within quotes, Musi caste, which is recognized as a scheduled caste under the Constitution of India, within bracket, Scheduled Castes Order 1950. The grievance of the petitioner are that they have been allotted composite land measuring about 7 bighas, 9 lessons, covered by dark numbers 2140, 2142 and 2145 in the revenue village Sohor Soronia Part 2 under Moza Udubari district Kamrup Metropolitan. Stop. The said plot of land is used as a graveyard known as Musi Kabristan for the burial of the persons, belonging to the said Musi community. Stop. It is the claim of the petitioners that some unauthorized persons had occupied portions of this land without any authority and are refusing to vacate the land and thereby causing hindrance to the purpose for which the land has been allotted to the petitioner society. So, because of the presence of these unauthorized occupants, the community and the committee members have been facing difficulties in executing, in performing the rituals for the purposes of rituals at the time of cremation of the persons belonging to the said community. Stop. Notice in the matter was issued on 27/3/2023. So, an affidavit has been filed by the DSP.
My lord, is a ADC, my lord.
The
two affidavit, my lord.
There is one by the DSP.
Yes, but DSP.
It it is stated that an FIR was filed by the petitioner. However, in view of the judgment of the court rendered in petition number 1331 of 2019, Dinonath Roy, as well as judgment rendered by the apex court in RE versus State of Assam, reported in 2018, volume 2, PLR 313. It has been held that it is only the special tribunal constituted by the State of Assam which can go into the various packets of Land Grabbing Prohibition Act and Land Grabbing Prohibition Act stop as such. The FIR could not be registered. An affidavit has also been filed by the additional deputy commissioner. Respondent number 3, additional deputy commissioner, Kamrup Metro, Guwahati. Stop. In the said affidavit, at para 4, there is a clear averment that land covered by tag number 2140 at village Sohor Soronia, part 2, Lubari Moza, is a government land and is recorded in the name of Muchi Koberstan. Similarly, land covered by tag number 2142 under the same village and Moza is also recorded as reserved for Musi Koberstan. Stop. Land covered by tag number 2145 is also recorded as Musi Koberstan. So, land covered by tag number 2141 is recorded as a road. Stop. In the said affidavit, there is a clear averment that during field verification by the lot mandal staff, the plots of land covered under tag number 2140, 2142 and 2145 of the village Sohor Soronia part under Udubari Mosa in the district of Kamrup Metro is reserved for within quotes Muchi Koberstan, and the same is also found to be possessed by some people constructing a temporary house and a sports club is also seen to be constructing an Assam type house besides some other commercial establishments. In view of the averments made in the affidavit, it's clear that the land covered by tribunal pursuant to are government land and which are earmarked for a Musi Koberstan, which the petitioners claim to be used for graveyard of the members of the Musi community, and the petitioner number 1 is the society in looking into the affairs of the graveyard allotted by the government. Stop. The affidavit does not, however, lay down any particulars as to whether the portions of land stated to have been under possession by some other person, including commercial establishment, have been allotted in the name by the government by following the due process of law. So, considering the prayers made in the writ petition and the averments made in the affidavit in opposition, this court is of the view that since there is already a representation before the DC, Kamrup, the same may be disposed of, and if any unauthorized occupants or occupations are found by the by the DC after making the field verification, then necessary steps be taken under the provisions of the Assam Land and Revenue Regulation and other ancillary provisions of law to ensure that the land which is allotted by the government for the purpose is used for the purpose, and all steps are required to be taken to ensure that the said land, the purpose of the said land is not restricted. Purpose of use of the said land is not restricted by undue and unauthorized occupants. Stop. The DC will conduct the necessary verification and pass the appropriate orders and take necessary steps under the provisions of law. And for which purpose, if required, personal hearing may be granted to the persons found to be in possession of the land. The effective steps be taken by the DC within a period of 60 days from the date of receipt of a certified copy of this order. Writ petition accordingly stand disposed of. That's the clear.
Nice, my lord.
The need stands again. Yes. Affidavit filed.
My lord, here I have filed the affidavit, but they raised one objection. A new paragraph is to be added now, my lord, as per one notification. That is not there. So I will have to modify it. My lord. I've given it to the registry, but they have refused to accept it. New paragraph is to be added. Phone numbers of the deponent and all is to be given by a new paragraph.
You complete it by
I can do it by tomorrow only, my lord. No issue.
by this week.
Lots.
Heard learned counsel to the parties. As per the last order dated 15/5/2024, an affidavit was required to be filed with the state. So Mr. B. Gogoi learned counsel to the state submits that the affidavit was prepared and an attempt was made to file it before the registry. However, in view of the recent change in the rules requiring specific paragraph reflecting the
phone number phone number of the deponent.
phone numbers of the deponents was not incorporated, and therefore the registry did not accept the affidavit without this change. So Mr. Gogoi submits that these rectifications as required under the new rules, under the amended rules, will be carried out within the course of this week. The affidavit will be filed accordingly. Mr. S. Mitral and counsel to the petitioner appears for the writ petition. Matter be listed after 2 weeks.
Kindly fix a date, Lordship, next week, anytime next week.
Anytime next week.
Lordship.
19.
Yeah, actually, but I was waiting for
And
the
you-
day, but
you have
I
to
think
mention
it
in
will
the
not
morning.
reach today. There is reference also.
Item 41.
Yes.
This has become infructuous.
Yes, because already one matter was disposed of, giving us liberty to initiate the department.
This is the earlier matter.
Earlier.
Okay. Where is the,
That order.
you're for the petitioner?
Yes.
Okay, item 41 is the request of learned counsel to the petitioner. Matter stands dismissed as infructuous. Interim orders, if any, stands vacant. Anyone appearing for the respondent?
7 to 10.
And my lord, I have taken the consent of Mr. Vishwas.
Learned counsel, so counsel appears for the respondent. Yes. Yes.
The petition is added by the whole created on its SBI account, Lordship, by the respondent, Lordship.
The hold was created in the year 2021, two lordship, 13 January 2022 lordship.
Yes, pleadings are ready.
Yes, madam.
You have filed pleadings. Right, we'll keep it for admission hearing on 11. Sorry, 13.
13 July lordship.
Yeah, we can have it on 13 July also. 13 July. is a holiday.
13 of this month.
18 July
18 July.
for admission hearing.
Lordship.
18 July. You submitted that pleadings are completed. That's not 18. Yes.
But on last occasion, the government was directed to obtain instruction. Later released to cancellation of caste certificate lordship. The deputy commissioner issued a caste certificate in my favor and subsequently it was cancelled. lordship.
We have raised the instruction lordship.
Yes.
We'll file a petition.
You want to file a petition?
Lodge.
Mr. R. Bora for the petitioner, Mr. M. Sami for Sami. Common advocate, submit the instruction that we received. We'd like to file an affidavit. He prays for 3 weeks.
Lord.
Time. It's the matter after 3 weeks,
All right, Lordship.
enabling the government to file the affidavit.
All right, Lordship.
Yes.
There we go. Oh, here is a case, my lord, where in spite of the direction, I applied a certain information under RTI Act 2005. Subsequently, it was not provided by the authority. Accordingly, we approached the appellate authority. First appellate authority could not. Subsequently, second appellate authority, my lord, directed the furnish the necessary information to me. But in spite of that direction is at Annexer J, page 41. That is the order dated 19/5/2023. But in spite of these directions, the concerned authority has failed to supply the information. So that is why I am approached this honorable court.
In this case,
And,
I am happy with response number 5 and 6. We have received instruction, but it is not sufficient. So we sought some further clarification to the response of 5 and 6. So some time may be granted to us.
In fact, my lord, 5 and 6 is the main authority to whom I approach, my lord. So some urgency is there. The order is way back in May 2023. Now we are in my lord, June 2024.
When can you file it?
After 2 weeks, Lord. After 2 weeks, some clarification is sought. By the
Heard Mr. Yes, 4 and 5.
4 and 5. 5 and 6.
5
5 and 6.
5 and 6.
Yes.
To submit that instructions for
Further clarification.
instructions received are not complete, that further instructions are not for. Therefore, submit that further 2 weeks time be granted by necessary affidavit.
No further opportunity available.
The second time we taken time.
The respondents are completed by the is made clean by the next 8 weeks. An attempt will be made to dispose of the writ petition. And if affidavit is not filed, court may proceed to dispose of the matter. Meeting available.
Wait, a specific date for that one.
After vacation.
Letter will be sent again on 19th July.
Highly obliged, ma'am.
Your Lordship, I am the owner of a lot of patta land, Your Lordship, and I have obtained NOC from the municipal authority, Your Lordship. Now, the NIT personnel are obstructing me from carrying out my construction, your lordship. Accordingly, I filed representation before the NIT authority as well as before the deputy commissioner. So nothing is coming, that's why I have approached this honorable court, your lordship.
Yes.
Lordship, I am appearing on behalf of Mr. S.P. Choudhury for respondent number 4, Lordship. And we will take instruction, Lordship, in this regard. Today we have it.
How much time do you require?
4 weeks time may be given.
So and so that a counsel for the submits on behalf of NIT respondent NIT Silchar. That further 4 weeks time, further 3 weeks time. Complete the instruction. Hearing to the petition submit that although does not object to the prayer made, however submits that he has to be listed immediately after litigation. Accordingly, listed on 19 July. 19 July.
Your lordship, I have an interim prayer, your lordship.
Interim prayer.
Your lordship, I have also annexed one order, this coordinate bench, your lordship. NOC was granted in 2023, your lordship, and I have purchased the materials. My materials are getting damaged, your lordship.
Then?
What the NIT authority have authority to obstruct when I am constructing my house on my patta land, your lordship. So I may be allowed to construct over my patta land, your lordship. I should not be disturbed, your lordship.
But there has to be a finding recorded that it is over your patta land.
Yes.
Then how by way of an interim order we can grant you?
That's why after verification of my record, the authority has given me permission. The authority. And according to the permission, I am going to construct, your lordship.
Where is the permission?
Permission is Annex 4, page 54, your lordship. Page 54. No objection certificate for construction, your lordship.
Where is the order of the NIT?
NIT, what order, your lordship?
So you are saying they are objecting you?
Yes, the personnel came to my place on 9/8/23 and 10/8/23, and the security personnel of NIT are obstructing me from construction, your lordship. Thereafter, I filed a representation on 17/8/23 before the NIT authority, and on 22/11/23 before the district commissioner Kachari, your lordship. There is almost 7-8 months has gone, your lordship, district commissioner.
It may be considered, Lordship, after obtaining the instruction, Lordship, whatever.
Almost 1 year, your lordship.
Then you do it under 2 weeks.
Lordship.
We'll fix a date before the vacation. You file your affidavit or we proceed with the consideration of the prayer for it.
Lordship, extra copies may be
Matter
provided to
be
us.
listed again on 26th of June, by which date the council for the NIT Silchar complete their instructions and file necessary affidavit. Prayer for interim will be considered on the next day.
As well as from the district commissioner, I think the district commissioner.
Let them file, whoever wants to file.
Alright.
May it please your lordship.
Yes.
This matters relates to the petitioner, my lord.
For the time being.
Time being.
Time. Lordship, may I pay for time being, Mr. K. Gogoi?
Today there is no time being.
He is there. My lord. Yes, sir. My lord, the petitioner before your lordship, my lord. His father has a plot of land, my lord, and after the death of his father, now all the brothers and mother has transferred the appropriate land to his name. Thereafter, he applied for construction of 3 stories, my lord, ground plus 2, before the competent authority. Now, my lord, the competent authority has allowed the construction. Yes. So, my lord, we kindly come to the annexure in the writ petition so that I can take your lordships to the annexures, my lord.
Are you arguing for a disposal today.
My lord, it will be a very short case, my lord, and there have been judgments of various high courts on this
Right.
point.
So if it is a disposal, then today may not be the appropriate day for a disposal. You'll have to hear all the parties.
I leave it to your lordship discretion, my lord, but there was urgency because he has constructed whole of the structure. Now they have stopped it, my lord.
You've been granted an interim protection.
Yes, interim status quo wherein I cannot construct, my lord. And all my cement and all other materials has been lying down, and my lord very well knows. Any short date, my lord.
We'll keep it for 13.
13.
Some few more days, my lord, I have to file my affidavit, my lord, from GNB.
Huh?
How do you
So why have you not filed your affidavit?
Well, it has come recently, my inspection has come. Let it be on 24th, my lord.
24th.
24th.
Available hello 24th
24th.
Lord.
It's on 24th. And the counsel for the respondents will complete their
we have hello
instructions and file
Public.
for admission hearing on 24th.
No, no.
Because disposal may take some time.
Yes, no issue.
Yes.
May it please your lordship. I am appearing on behalf of respondent number 5 and 6 LIC. So I have already filed affidavit in application.
Okay. We need to file my reply.
You need to file
Reply.
reply.
Madam, I'll file a short affidavit. Though we are not the main contesting party, we have done, the relief is basically against 5 and 6. But as the bank, it was our duty to forward the document. We just file a short affidavit. And we are not opposing the claim of the petitioner.
Mr. Ganguly, learned counsel for the bank, raised for it, week further time. Right. Invite the respondents 5 and 6, have already filed their affidavit. Mr. L. Mohan, joined the affidavit at grade 4. It is the matter in the month of July on a date to be fixed by the registry.
Hello.
Also in item 35 of the law, this matter may be take with application number 2087/24.
Yes.
Lordship.
It is submitted that a similar reflection is pending. Both instances be together. The submitted listed along with WPC
2087/24.
2087 of 20. When is that matter big?
Lordship, matter not, date not given here.
Both the matters be listed in the month of July on a date to be fixed by the registry.
Lordship, I have a very limited care, Lordship. My second appeal is pending before the RTPS Commission, Lordship. That may be disposed of, Lordship, by in a time-bound manner, Lordship. Similar petition has been disposed of, Lordship.
Now, why have you come before the court?
Lordship, I have come before this court for mutation of 10 leases of land. I have applied in the Seva Setu portal under Bosundara 2.0. I have applied before the authority, Lordship, but they have not provided the service under the Right to Public Service Act 2012. Thereafter, Lordship, I filed a first appeal before the district commissioner. After exhaust of the statutory period of 60 days, I filed a second appeal, which is pending before the RTPS Commission. And that has not been disposed of. Lordship, may I place this order, Lordship? I filed another writ petition. In terms of the said order, Lordship, the petitioner has got the relief. His other plot of land has been partitioned.
Your prayer in the writ petition is different.
Yes, my prayer in this petition is for mutation of 10 letters of land. I have applied in the Saraswati portal with all the relevant documents.
No, you have two prayers. You want the disposal of the first appeal. Prayer number 2.
Dispose of the first appeal dated 30/10/2023 and second appeal dated 1/1/2024. Both are pending. They have not neither rejected nor have provided any.
Yes.
I am representing respondent of 4 lots.
Who is respondent for?
Deputy Commissioner, District Commissioner.
And appeals are pending where?
Before the RTPS Commissioner.
Respondent 3.
No, sir.
Who's for respondent 3?
In this case, also notice was issued. There are 2 orders passed by the Honorable Court lawsuit. On 21/2024, it was fixed for
Government
inspection.
advocate has accepted notice on behalf of respondent 3.
Then that's why I need some time then. Then I need some more time.
Mr. N. Goswami, learned additional senior government advocate. Prays for further time to complete the prayer. Common made in the writ petition that his first appeal dated 30/10/2023 has remained pending and they will not dispose of by the respondent 3. Since by issuing notice, government advocate has accepted notice of the applicant's for 3. The learned government advocate will apprise the court as stated the agency first appeal dated to have been pending. Respondent number 3 had to be listed in the month of July. The date fixed by the registry.
After 2 weeks,
Lordship, an endeavor shall be made to dispose of my writ petition.
On the next date fixed, an endeavor shall be made to dispose of the writ. The rights के साथ. Yes.
Obliged.
None appears for the petition. Mr. Yeah, you're appearing?
My lord, earlier order was directed to a respondent operative to file affidavit, my lord, regarding estimate of the land acquisition amount. my lord.
Yes, Mr. Sharma.
Lordship, on 2/5/24, the Water Resource Department has written to the DC of Dhemaji to give the land estimate, Lordship. But till now, we have not received any. No.
Yes.
They have sent one letter to the Deputy Commissioner Lordship for submission of LA estimate Lordship. In this case, I think this is some special.
Government council shall pray for further time to take their actions. Still. Okay. Yes.
Obliged.
In item number
Lordship, in item number 62, we have filed an IA. What has happened, bank in the meantime on 3/6/2024 has furnished a letter to us. The last page of the IA.
Physical possession.
Physical possession, Lordship. Now we are taking steps in the DRT because we have received a letter on 6th. Lordship, only for, because on 11th tomorrow, they will take physical possession only for 2-3 days, Lordship, we need some accountability. Because Lordship, a review is pending of the parent judgment. And they have received notice but have not appeared.
Yes, not in the main writ petition, we have annexed the detailed order and judgment in the essay that they had filed. The essay was dismissed. And my lord, now they have filed some review. There is no interim order in the review. During the pendency of this writ petition, my lord, the DM office has passed an order. It is dated 30th of March 2024, but we also received it on 1st of June only, when we went to inquire. That, my lord, is there. And they may pursue whatever remedies this writ petition.
Which officers passed the order?
The district magistrate, the deputy commissioner.
Regarding
taking of physical possession. What had happened, my lord, if your lordship sees the order dated 1st of April in this case, this court made it amply clear, my lord, that the pendency of the case shall not be a bar to, my lord's, passing the necessary orders. Lordship will have Lordship will have the order dated 1st of April, my lord, 2024, wherein, my lord, it is stated that pendency of the petition shall not be a bar for the respondent number 2 to pass appropriate orders on the petition filed by the petitioner bank under section 14 of the SARPESA Act if permissible in law. That made it clear. Following that, we submitted a representation that since the court has made this observation, to kindly proceed. They apparently passed some order, but perhaps because of the code of conduct, that further steps were not taken. Now on 1st of June, when we went to make an inquiry, they have given us a copy of that order. Well, it's not that it is going to be taken on 11th, or it will be taken. Well, they will have their remedies in law. This petition can be disposed of on the basis of that order passed. Because our petition was essentially for that purpose only, section 14 order. That has been passed.
Where is that order?
That, my lords, is not on record. Our lordship may keep it on Wednesday. We will place it on record. Or on Friday.
Lordship, that order we have to also not been provided by the bank.
We place it by an affidavit.
So, but you have remedies elsewhere.
Yes, we have taken steps, but Lordship would see the letter. It says that if you don't give the possession, the bank will take over by tomorrow, 11. It is given in the letter.
That is how the things proceed after dismissal of your proceeding.
No, review petition is pending.
But have you gotten any interim order?
Interim order, no, but bank has received the notice. We are we are bringing it to the notice of the DRT. We are taking steps, but tomorrow it's too early. Therefore,
when did you file your review?
Lot of review long back. It's 7:45 now. Review filed on 18 October 2023.
Then, since then you have not got any interim order. How can we pass an interim order?
No, Lordship, these steps were not brought to the notice. Now only, Lordship, we came to know. In fact, the DM's order, we have not been provided a copy. We'll approach by tomorrow, we'll approach, Lordship, DRT.
You approach, you do whatever you want to do.
But tomorrow is the deadline given that bank will take over.
What provision do we grant a stay? Under what provision? Where is the illegality?
This IA is not maintainable.
Lordship,
There is the illegality.
Lordship, just a review petition is pending firstly. Secondly, Lordship, the copy of the order has not been provided to us to seek a remedy, Lordship. But still we are bringing it to notice of the DRT. Lordship,
the respondent as an applicant for this court praying for interim orders in respect of the communication dated 3/6/2024 by the Punjab National Bank requesting the petitioner to hand over there are Mr. Gandhi on the other hand, that under section 14. The district magistrate has already steps and passed necessary orders for securing the
Physical.
physical possession of the assets. So, counsel for the petitioner submit that he has not been served a copy of the DM property
Counsel for the applicant in
applicant. And counsel for the bank submit that you'd like to bring that order by way of an affidavit. When?
No, sir, we'll file it tomorrow. Lordship
The
in
matter be listed on Friday.
Right.
Invite. Till the next week. The bank will not.
no, that order may create a precedent. My lord. That is that Lordship will. I assure Lordship, my lord, till Friday,
Till
no physical
Friday,
portion. My lord.
till
Lordship will
Friday,
record.
Let there be status.
That order, my lord, because this IA is not maintainable. My lord.
We'll hear it. Suppose it on Friday.
No, this order may not be a precedent in other cases. Because Section 14, my lord, he has no right. My lord. The Supreme Court has made it absolutely clear. Lordship will record my statement. We will not take physical position, my lord, till Friday. Otherwise, my lord, it will be very difficult.
Difficulty in getting a status quo order till Friday.
My lord, the difficulty is, my lord, for any reason, my lord, the matter gets extended. And in other cases of Section 14, my lord, they will file, the borrowers will now come up with IAs for stay orders, my lord. My lord, it is incumbent upon him to approach me, not for him to file an IA in my petition.
You remind us on 14.
Lordship. If the- Come.
Thank you, dear Lordship. This matter pertains to non-payment of compensation, my lord. Actually, my lord, the government of Assam, under the Assam Mala scheme, a land of the petitioner has been acquired, my lord. Some of the compensation has been given, but my lord, I have a RCC building standing there, my lord. The building extends to the land which has already been acquired, my lord, but the building has not been assessed, my lord, and compensation has not been given. In this regard, the petitioner submitted representations to the concerned authorities, but they have not responded, my lord. The land has been acquired by the way of direct purchase, my lord. Notice has been issued, my lord. Respondent has not been filed till that, my lord, any response, my lord.
Yes.
Instruction awaited, Lordship. More time required.
And it says forward and a cabinet further time. The records will carry it. It's after 3 weeks.
Obliged, Lordship.
Yes.
The last occasion, Your Lordship, we had to file a rejoinder. We couldn't file it. We'll be filing it in the course of the day or tomorrow, Your Lordships.
You're not filing.
We will file it. We'll just,
Filing.
yes, we'll file it in the course of the day or perhaps tomorrow. Tomorrow, we'll file it tomorrow, Your Lordships.
All right. Tomorrow is more auspicious.
No, no, we'll file it. The only thing is, Your Lordships,
Yes.
the fact remains is that on the last occasion, they have filed a counter affidavit. They have said in regards to certain anomalies that were pointed out in the representation that we filed after the technical bid was opened. We had pointed out certain anomalies which the department have now said that yes, there are certain anomalies, but that they have a right under the NIT because certain powers are cured and they can exempt it.
You file your rejoinder, we take it up.
I'm only seeking this much indulgence, Your Lordship, because I don't know whether the work order has still not been issued. If it is issued in course of this, Your Lordship, it will prejudice me. So I'm only requesting if that could be limited to that only. I'm not saying, I understand it's a revenue matter.
Work order.
Lordship, if there was no interim in the beginning, Lordship, probably it has been.
No, work order issued or not issued?
Lordship, for that, I'll have to seek instruction.
Yes, you're for the private respondent. Yes.
But in this restitution, in the present form, this restitution is not maintainable because the letter of acceptance is not under challenge.
Work order issued.
Letter of acceptance is already issued because of the code of conduct. Work order was not issued. Letter of acceptance already received.
It's not been.
It is not under challenge.
They have not even filed it in the counter also, it's not been annexed in the
The thing
by the state government.
petitioner approached the honorable court prior to that the letter of acceptance was already issued, but that is not a part of the rectification.
Whether it was copies were served upon the petitioner? No. Letter of acceptance will be issued to you only, the L1 tender.
Yes, madam.
Then,
but there is no whisper in the rectification.
I may not
And
know
he,
about it.
during the course of the first day of the argument, he knew that the letter of acceptance.
what
was
is
already
the
issued.
tender about?
IMFL offshore,
IMFL?
offshore. Only to limited extent, otherwise the entire effort.
The difference is more than 1 crore.
When can you file it?
I can file it tomorrow morning, first thing in the morning.
As per the last order, it is so and so. Petitioner will find their affidavit live. The counsel appearing to the petitioner, Mr. Rajiv, submits that those of reasons beyond control, the affidavit will be filed. He submits it to be filed in 2 days. So, submit the matter be listed again on
They're convenient to your lordship.
all days are convenient to us. You tell us your day.
Thursday, 24.
On 19th,
19th.
19th,
Yes.
Mr. Botapul appears for the
Can it
State
be
Department.
18th if it is not inconvenience,
Huh?
your lordship? 18th if it is not inconvenient.
My lord, put it on 21st.
21st.
19th is immediately after the Eid, my lord, possibly.
24th, then we keep it on 24th.
Okay, my lord.
24th. Mr. J. Abedin here to the private respondent. It's provided that till the next date, 24th, if the work order is not issued in the meantime, same shall not be issued without.
Next immediate.
24th.
24th.
We are inclined to extend your increment.
My lord, only one thing with your lordship's permission, my lord. What my lord has said, the letter of acceptance was known to them or not prior to the filing of the requisition. It was known to them because I filed a caveat and that caveat was, on the first day, the caveat was discharged, my lord.
You argue your case. You argue.
My lord, actually, there is no ground at all for the stay of this work order. my lord.
You are not available from 18th. You are not available from 17th or 18th. We can fix it on 18th if you want.
Then, my lord, I think your lordship suggested on 19th. 19th will be. No stay should be granted, my lord.
No, till 19th. We'll cut short the period of stay. We are not giving a stay because of any other reason. The fact that it's your work order till date has not been issued.
My lord, the work order was not issued because of the code of conduct.
Code of conduct was lifted.
No, my lord.
And
On
19th of
6th
December 2023.
No, it was only 6.
Right, that's all right. Till 19th. Let it be there till 19th. Yes.
I have no proofs. 19th I have no proofs, provided my lord has it.
Is it all right, Mr. Abedin?
19th? 24 or 19th?
List again on 20th.
Great.
19th,
No, my lord, let it be on 21st.
21st is not convenient.
24th is
We can have it on 24th.
24th is fine.
We can have it on 20th.
My lord, on 24th. With your lordship permission, if I suggest, my lord, that there may be a, my lord, thing that it will not be extended.
He's already said.
Extension of the interim order. Will be considered on 24th if required.
Great.
May I please, your lordship? Lordship, in this case, lordship, we have challenged the adjudication order dated 27/9/2023.
Lordship, the main ground of challenge before your Lordship is that, Lordship, this order has been passed on the dictation of some senior officers. Lordship, may kindly see page 319 of the order. There is complete non-application of mine by the officer, and it has been passed only on the dictation of the senior officer. Page 319.
Yes.
Lordship, page 319, 2.7, Lordship, the paragraph 2.7. 2.7. Okay. Where subsequently a letter was received from the superintendent of anti-evasion so-and-so regarding recovery of interest on net case liability with effect from so-and-so under the provisions of section 50. Under section so-and-so, and as notified by CBIC with effect from so-and-so, as per the communication received from the superintendent and so-and-so, the taxpayer was liable to pay so-and-so as interest on delayed payment of tax from July 2017 to January 2021. Lordship, that is the only observation so far as, Lordship, this amount is concerned. There are two amounts which is under consideration in this adjudication order. One amount I have already paid. I have accepted the in which, Lordship, they have Lordship, this amount, Lordship, and I am challenging this amount, Lordship. I have made the entire payment of taxes. Only the payment of interest is there.
Pleadings are complete.
Lordship, they have not filed the affidavit, and Lordship, that interim today it is fixed for interim consideration, Lordship, this matter, because they had to.
Yes.
Yes, Lordship, I have to take instruction. I have already filed my department on 9/4/2024 to take instructions, but by virtue of the order dated 8/4/2024, Your Lordship. That is the order. Accordingly, I have taken instruction, but not been received.
What is the final order?
Lordship, the final order, page 325. I confirm the demand of interest. Tax amount I have already paid, Lordship.
Recovery notice issued.
Lordship, that I have paid some amount already, Lordship. Lordship, in page 327, but Lordship, they have started issuing recovery notices, Lordship.
Where?
Till now, the recovery notices have not come to me because the matter is pending, Lordship, but Lordship, I may be protected.
But unless they recover you, we are examining your order anyway. But where is the apprehension for recovery without a recovery notice?
Lordship, there is always an apprehension because the appeal demand notice has already been issued, Lordship.
The recovery notice.
Lordship, this demand has already been issued. So, Lordship, at least, Lordship, if the stay is not given, at least no coercive action may be taken by them, Lordship. At least this may be provided by them.
Yes,
at least that.
they heard learned counsel for the
That can be done.
We record your submission. Then it can be done.
No, Lordship, I said about my statement is to take instruction.
But Dr. Gogoi learned hearing of the GST. Submit that the
Lordship.
although notice is very on 8/4/2024. Accordingly, further time trade for
Lordship.
matter be considered after 4 weeks. Meanwhile, no coercive action against the petitioner in respect of the assumed order. Dated
27/9/2023.
page number
316, 316. 316.
No, 325 is the order.
316 is the 325 is the voting.
Right.
31 against the order dated 27/9/2023 passed by the Assistant Commissioner GST Central Excise within bracket and ensure 24. Yes, Mr. President.
I agree. The Health Department, Health and Family Welfare Department, since 2021, there is no tender at all, my lord. And now the courts, this honorable court has issued a direction. The lordship will find at page 53. as per the statement made by the government advocate, my lord, on the basis of that the court has directed to issue a pay standard notice. And if this order was passed, my lord, as per that, on 35 to 2023. And the order was that the tender should be issued forthwith. And thereafter, government has taken a decision, my lord. Earlier it was made centrally, and now it has been decided that there should be tender, issuance of tender from the district. Now, the district authorities, they are saying now that they don't have any infrastructure. NSR 11 series, these are their letters, my lord. So if in this way, my lord, then there will be no tender, my lord. So my prayer, my lord, that it should be done centrally. That is my prayer.
Yes.
That is,
My lord, I have received the instruction, my lord. There is a decision regarding that, my lord. It should be done district-wise, my lord. So now the district where the infrastructure is not there, my lord, that will be made available, my lord. But centrally, my lord, because there is a notification, there is a decision that it has to be done district-wise, my lord.
You bring it on record. Your
Yes, my lord. I will file the affidavit. I have received the
Will you
paragraph.
file the affidavit in the matter?
Yes, my lord.
Heard Mr. D. Chaudhary. Ah, help. Let the affidavit be filed. Read it out.
10 days, I will file.
2 weeks.
2 weeks, my lord.
date may be fixed.
It will be dated after 2 weeks. A date will be fixed by the rate.
Obliged, my
You
lord.
want a date?
Yes.
26.
Once.
Obliged, my lord.
Please, your lordship, also this incident matter pertains to revocation of my passport without providing me any orders or speaking order. Lordship, I have received the instruction, lordship, let me file my affidavit, lord.
Heard. Yeah. Let the affidavit be filed within 2 weeks.
Lordship,
To be listed again on 26.
lordship, let it be after vacation because I have to send it for vetting, lordship.
All right, then matter be listed immediately after reopening.
Lordship.
17th. Like.
Lordship. Much obliged.
The matter is very on a narrow campus, but due to the bona fide inadvertence of the accountant of the petitioner firm, the date was inadvertently put at on a retrospective date. That was in the year 2020, the date was incorporated, but we had filed the returns till 2021. For that difference, now the input tax credit to the third party, they could not avail it.
Let us have our instructions, my
my
lord.
lords, and the director.
Our instructions are awaited, my lord, in this matter, my lord.
On 2 occasions, my lord, they had short time for filing an affidavit.
We'll file our affidavit, my lord. We're waiting on instructions, my lord.
You first get your instructions. We'll give you 2 weeks time.
Maybe.
Let the matter be listed again on 26th of June.
My lord.
Meet.
By which time the respondents are expected. File necessary affidavit.
Highly obliged, my lord. H. Borua.
H.
Borua.
Borua.
Obliged.
Yes.
Finance and taxation.
Finance and taxation.
Obliged.
Yes. It's next week. I'll be for BTC.
I'm preparing for I appear on behalf of D. Gove for petitioner. It has some personal difficulty, lordship. May fix it on any other date, lordship.
Yes.
Also, I am for respondent 3 and 4 also. Actually, when this matter become infrastructure, already their tenure has been expired. The normal tenure and extended tenure also.
Let us have it on Friday.
Friday.
Friday. It's on Friday as it is submitted that the council. For
Respondent 3 and 4.
or agriculture.
J. Bormon on behalf of Jacob become standing council deputy. Sorry, my lord, standing council Apex. Respondent number 7 there.
FX spec.
Yes, Apex also there also.
Branch manager, number branch.
Yes, Friday.
No, Friday.
In this case, we have to take instruction on the present status of the case. Weeks may be granted.
No, if it is infractuous, then why? He says the term of the committee is
Also, the normal tenure is 3 years, also, when extended tenure up to 1 year. The first meeting held on 18 to 2018. And so the normal tenure expired on 18 to 2021, and the extended tenure expired on 18 to 2022.
So if it is expired, then what will be? Date petition was filed in 20.
That's it. Also, the challenges, they filed some petition before the secretary. So she take time first, because whether they dispose of or not.
You will get the instructions by Friday. Friday.
Highly obliged.
My lord, this is for release of my lord security deposit, and the honorable court has already directed the respondent to file their affidavit, my lord.
No affidavit.
No.
Some time may be granted since this has come up
Already,
after
my
a
lord.
while, Lord. We'll file it positively in 2 weeks, Lord.
Yes, but
Yes.
it's an IA.
I am, my lord.
The applicant. And, I it's not applicant, like the applicant. Therefore, wait for again after 2 weeks, 3 weeks. I think
2 weeks is better, my lord.
after 2 weeks.
Yes, my lord.
Then also it goes to July. We'll have it in July. The month of July.
Obliged, my lord.
Matter is regarding non-payment of contractual amount, my lord. Due to construct.
Where is the admission? Where is the admission?
Admission, my lord, B series, my lord, annexure B series.
Annexure B series.
Page, my lord,
Page number.
page 33. 31, my lord.
Yes.
Total amount, my lord, 18 lakh 60,000, my lord. For the construction of low cost individual household Latin.
Page number 31 is 3 lakhs.
My lord, the different bills are raised, my lord.
Okay, then
Then, my lord, page
where is the admission of the department that you have done the work?
my lord, the competent authority signed this bill, my lord. Authority has signed this bill, my lord.
Authority signing this bill is a different issue, but there has to be a, where is the work completion certificate? Where is the work completion certificate? Mr. Pothapur, any instructions?
Perhaps, Lordship, this can be disposed of with a direction to the chief engineer to verify.
All right. Heard, disposed, verification to be undertaken by the chief engineer, water resources, public health.
Yes, my lord.
Public health, respondent number 2, within a period of 60 days.
Yes.
On the date of receipt of a certified copy of the contract and thereafter make payment from there. Disposed.
Oh, my lord.
MS Borua for Respondent number three. Mr. Rai Thakur for the
Lordship, I may be allowed to withdraw this petition.
No, Lordship, I have a prayer, Lordship. In this case, I am appearing for respond number 2, Lordship. At my instance, matter is listed, Lordship. I had filed one affidavit, Lordship. What happened in this case, Lordship? One proceeding was is pending before the micro and small enterprise.
He wants to withdraw.
Lordship,
Withdraw the writ petition.
Lordship, I want to withdraw it.
Oh, then,
Nothing remains.
yes.
Nothing remains.
That's why, Lordship, I have bring this a record, Lordship, by filing an affidavit, Lordship, because that proceeding was already closed, Lordship.
Mr.
B. Hazari.
B. Hazari. Ex-gratia.
Respond number 2.
I got respond number 3.
Mr. P. Pathak for respondent number 3. It's submitted by Mr. Hazarika. The petitioner does not wish to proceed with the writ petition and it's able to become according the writ petition stands in principle and practice in order if any standing.
Obliged.
Yes.
May I please, your Lordship, on last occasion, notices were issued, Lordship.
Lordship, I'm appearing on behalf of the respondents. We have filed our wakalatnama today itself, Your Lordship. So Lordship may grant us 2 weeks time to file our objection.
This is for under 11.6.
Appointment of sole arbitrator.
Under 11.6.
Lordship.
Very well. You are appearing on behalf of the respondents.
Yes, Your Lordship.
Okay, heard. It's Kanungo, it's the petitioner, MS
M. Zomantui. I'll write it down, Your Lord.
M. We appears for the respondent who submits that that they represent the respondent and like to file their objection. It is of 2 weeks
2 weeks, Your Lordship.
to be extended till July.
Obliged.
Yes.
So basically, Lordship, the case is that Lordship, the respondent hearing Lordship was filed a revenue appeal, Lordship, pending before the revenue board.
No, we'll have to await service report of respondent 2. Who is respondent 2?
Respondent number 2 is the Lordship Maroi Thakur. It is the appellant in revenue appeal. But you kindly have a look at page the last order.
Yes.
On that day also, the respondent has stated that also they are going to appoint a division bench of revenue board. What is the status of that? What is the appointment council informed?
Yes.
We have placed an instruction, my lord, that a process of appointment is going on, my lord, under process. On the last occasion, also directed to this updated instruction, my lord, that we have not received yet, my lord. So only some time, my lord.
Mr. J. Kodita appears for the petition because we are on standing down the Department of Revenue. Disaster management submits that our instructions are awaited. Therefore, for the type granted.
After vacation, my
Let the matter be listed after 2 weeks. Date fixed by the rate. Anyone else appearing? Yes, last appears for.
We don't have 59.
You are appearing?
Respondent number
I mean, that's 4 for 3. That's all?
Lord.
Are you appearing for someone?
Obliged.
May please, Lordship. My lord, as per the last order, my lord, the Lordship produces the last order 10/5/2024.
No, 10:30.
Service in case of respondent number 8 is still awaited.
No, my lord, I am
And
appearing, my lord.
Respondent number 8.
My lord,
Service is complete, my lord. And
here the issue is this one. His lordship, this requisition may not be maintainable, or it is may not be entertained by this honorable court. What happened, my lord? We have acquired this one for national highway. We have required land for this, and only land was acquired. Thereafter, key notification was published. Then the land 3D notification also published.
We'll hear this for admission. Let it
Yes,
come
my
for
lord.
admission.
Yes, my lord, because little early. Why? Because what happened, my lord? Due to this, though stage not operating, my lord, then one of the player is there. That is why also, because that service should is unable to construct. Because
There
this,
is no interim order.
that is a, but one, my lord, we also, it is a,
There is no
sometimes,
interim order here.
no interim order, no interim
The
order.
authorities have given my structural compensation to a person who is of my same name. That is the
Yes,
only case here.
that
And they
is
have
the
admitted.
issue.
They have admitted in the annexed
Yes,
case,
that
my
is the admitted issue, my lord. That is why there is a provision under section 3A 4 of National Highway Act. If any personage branches, because after 3D, my lord, nobody can come to court.
My lord.
Here is clear. Let me submit for your betterment. I'm
Yes,
telling.
yes.
This 3D, after 3D, nobody can come. Thereafter 3G will come. Compensation. It was decided. What happened, my lord? Kala has committed mistakes. We have paid the amount, 50 lakhs some amount to them. But Probin Bora, they have paid to another Probin Bora, my lord. That is the issue. Now that is why, what happened, my lord? Now in that case, what will be this one? That will come 3H, my lord. Now, according to them, it is pending.
Mr.
My lord, I am
Another
appearing
Probin
for
is
eight.
appearing.
My lord, I am for 8, my lord. It is not that the wrong person has been given, my lord. I am also entitled for the same land
Yes,
acquisition.
yes.
So I will come on the affidavit.
Yes, that come. But this can be not by this honorable court, my lord.
It is a proforma respondent.
It is,
Yes.
it is Miller by this, it will be decided by lordship,
I am
letter
the-
by
I
the
am the
principal
proper-
judge.
Proper respondent, my lord.
That is why, my lord,
My
I
lord,
am
let
telling,
them
my
file the
submission is
affidavit.
that this has to be adjudicated by the, as per provision of law, this is by the principal judge of that particular district. That is what is pending.
We'll take it up for
Yes.
admission.
Next week, my lord, because it is the,
Matter will be listed next week.
next week, my lord, because though it is not there, because we also sometimes feel. Next Thursday, my lord, or next
On 19th.
19th.
My lord, that will be anything there.
No, early means what we can
want
do.
to
We
file
are,
affidavit.
I will find.
we am suffering, my lord, because road is been
But
reconstructed.
there is no interim order. Why?
Yes,
And that is there, my lord. Then also sometimes what happened, my lord.
It is up to you to consider
Yes,
not
that
carry
if-
on. There is no
Nobody
restriction
is
order by
stopping
the
them
court.
from constructing.
Or then now if he's saying that is very, very good.
Because
Submitted, nobody is
already-
stopping,
already
nobody
I
is
have
stopping
appealed.
demolish, I'll demolish, my lord, no doubt.
I have already
Because that's by
appealed.
his submission.
We'll have it on 24th.
My lord, my lord.
List on 24th.
Yes, my lord. I'll do needful now.
My lord, can it be a little earlier because on that day, my lord, senior counsel, Mr. Dafi, be out of state.
It can be little earlier. They have to file an affidavit.
19 will be my.
19th we are agreeable, but he says 19th.
How about then?
19th.
19.
List on 19th.
Right.
As agreed to by the learned counsel.
By this time, I will find it.
Yes,
By which time the respondent number 8 will attempt to endeavor to file the
Affidavit.
affidavit. That's great.
Pass.
And when 2 and 3, my lord.